But already late, so we save time.
Before we begin this session, I humbly request all the honorable guests, the esteemed participants, and respected members of the audience to kindly rise for the rendition of the national anthem of India and join us in the shared moment of national reverence and unity.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you. The arc of the moral universe is long, but it always bends towards justice. The bench is where the conscience of society meets the rule of law. Namaskar. We are delighted to welcome the honorable guests, the esteemed dignitaries, and distinguished participants to the first session of the East Zone 1 Regional Conference on Contemporary Judicial Developments and Strengthening Justice Through Law and Technology. This session is on constitutional morality and contemporary constitutional trends, with focus on evolution on the concept of constitutional morality vis-a-vis social morality, the judicial approach, judicial innovation vis-a-vis constitutional trust, activism versus overreach, and cooperative federalism. This session is to be chaired by Honorable Shri Justice Suryakant, Judge, Supreme Court of India, and the speakers for this session are Honorable Shri Justice Chakradhari Sharan Singh, Chief Justice, High Court of Orissa, and Patron-in-Chief, Odisha Judicial Academy, and Shri N. Venkataraman, the esteemed Additional Solicitor General of India. The best time to plant a tree was 20 years ago. The second best time is now. So before we begin with this session, I request Judicial Officer Ms. Jasaswini Mahapatra to kindly present Shri N. Venkataraman, the esteemed Additional Solicitor General of India, with a sapling. Thank you. I now humbly request the Honorable Chair of this session to kindly commence with the session.
Without any formal address, and just to save time because we are already late, let me just give my opening remarks on this subject. This session, of course, as the computer has pointed out, we are going to discuss the constitutional morality and contemporary constitutional trends. This session aims to provide an invaluable platform for critical discussion on topics that have taken, in fact, in these days, rather in recent years, it's a real central stage. Friends, the contemporary usage, constitutional morality has come to refer to the substantive content of constitution. There was a second usage that Dr. Ambedkar was more familiar with from its 19th century province. And that says, in this view, constitutional morality refers to the conventions and protocols that govern decision making where the constitution vests discretionary power or is silent. So that's what the area of constitutional morality was sought to be defined and identified. It's important to understand the true meaning of the terms constitutionalism and constitutional morality, their origins and their position in the constitution to prepare us for this discussion. Now, what is constitutionalism? As I personally believe, the definition of constitutionalism consists of two aspects. First, that constitutionalism requires control over the exercise of governmental power. Why? To ensure that it does not destroy the democratic principles on which it is based. And second, that courts must interpret legislation on the assumption that Parliament would not wish to legislate contrary to fundamental rights. That's a presumption. That's why every legislation carries that presumption. And always understand, the Constitution is a living heritage. No one can destroy its identity. These are the fundamentals. Now, Grote has defined constitutional morality, and he says, by constitutional morality means a very long definition, but please see very interesting words he has used. A paramount reverence for the forms of the Constitution, enforcing obedience to authority, and acting under within those forms, combined with the habit of open speech, right to speak, of action subject only to definite legal control. No action can be taken without legal control, means that unless the force of law, you can't be prosecuted. With a perfect confidence amid the bitterness of party contest, that the forms of constitution will not be less than sacred in the eyes of his opponents than his own. Such a long definition, but very comprehensive and a composite definition he has given of constitutional morality. Now, Dr. Ambedkar has also a view. Dr. Ambedkar, during Constitutional Assembly debate, particularly when discussing the need of administrative provisions in the Constitution, the justification for including such elaborate administrative provisions was that the form of administrative requirement have a close connection with the form of the Constitution. The form of administration must be appropriate, according to Dr. Ambedkar, and in the same sense as the form of the Constitution. The other is that it is perfectly possible to prevent the constitution by merely changing the form of the administration and making it inconsistent or opposed to the spirit of the constitution. And why it was Dr. Ambedkar felt like this? Because Dr. Ambedkar fears on the fact that he believed that Indian soil to be essentially undemocratic. That was the fear he expressed. And this is the reason not only administrative provisions but also limitations on the government's power are embedded in the constitution. That's why so elaborate arrangement in the constitution. That fear was there in the mind that ultimately, because we have been ruled for generation to generation, so we may not be something undemocratic insights are there. And that's why so much comprehensive administrative arrangement consistent with the constitution was embedded in the constitution itself. Now, when we talk of limitations of the government's power and the inherent, which are inherent in our constitution, and then we take the power of judicial review as basic structure, let me just briefly point out on that also. The one such limitation on the court's power of judicial review is explained in case Keswaran Bharti. The Supreme Court said that Parliament's power to amend the constitution is not absolute, can't be exercised to damage the constitution or the basic structure of the constitution, and to hold it lies the power of judicial review with the constitutional courts. The last word lies with the Supreme Court. This is how it was believed. There is no doubt about that. Judicial review is part of the basic structure. The judgment further says that judicial review itself is a part of the basic structure. And then it was reiterated in so many judgments, including, you know it, Indira Gandhi Rajanarayan's very famous judgment on election law. Now, on the overall overview of the three main critics of the judicial review, when we talk of the power of judicial review, we must also acknowledge, we must also be aware of that our power of judicial review is not something universally accepted. It is not beyond criticism. It is not that it is without any debate or murmuring, it is accepted by the other stakeholders. It is not like that. There are three very important criticisms, and I have very briefly tried to note down them. One, they say, an oft-cited critique of judicial review is that judges tend to rewrite the constitution. That's the first criticism normally judges will face. That when you, under the garb of your power of judicial review, you always attempt to rewrite the constitution. Article 14, they say, it was never construed, never, the constitutional drafters never meant like that, the way the courts have interpreted. Therefore, accusation is that we have attempted to rewrite Article 14. I remember, and Mr. Venkatraman will definitely recollect, in one of the judgments by sitting with Justice Nariman, our bench, we struck down a part of the Arbitration Act of the amendment in the Arbitration Act, and we used that was a terminology we coined. We used the word manifest arbitrary. Manifest arbitrariness is also one of the ground where a statutory provision, a parliamentary legislation can be struck down. So there was a lot of criticism that we have been hearing Article 14, we have been hearing 16, 21 violation, but now this new ground has also been coined to say that even on the ground of manifest arbitration, a legislation can be struck down. So this is how we are being criticized. On Article 21 also, all of you know, the way the Supreme Court in passage of time has given meaning to it as making it a very, very live provision that has also not been really liked or appreciated by many stakeholders. They feel that what Article 21 was never intended has been unnecessarily incorporated in it. And most importantly, they say the expression due process. As you know, the due process expression is an American constitution, and our drafters have specifically excluded this, and when they substituted the procedure established by law. But in the course of judicial interpretation or judicial review of Article 21, we have now added expression due process also along with procedure established by law. So this is one criticism, that we are trying to rewrite the constitution. What is the second? Second is on the premise that each word of the constitution has a set definition decided by the drafters. That each definition is so complete and so absolute that to alter it would equivalent to rewriting the constitution. That's I'm summing up the. But what is being forgotten is that Constitution is a living document. This is the reason that drafters included words like liberty, equality, fraternity, and so many other words without defining them. Because they knew it. These words and their interpretations are bound to change with the passage of time. And why with the passage of time? Because the needs of the people will keep on changing with passage of time. And therefore, the Constitution is meant to address the growing issues before the populace, before the people, for those people who gave that Constitution to themselves. So therefore, it has to be kept as a live document, a running machinery which can be molded, directed in a manner that it can effectively respond to the situation that is being faced by the people at that time. That's why Justice Hand says, and very beautifully, he says, fundamental rights are empty vessels into which each generation pours its content by judicial interpretation in light of its experience. And that's why it is known as a living document. Now, the concept of PIL is also another area which has been criticized, and even today it is every day it's a subject matter of criticism. Now, within judiciary also, we are very circumspect, we are very apprehensive in as far as the PIL part is concerned, and we are very quite selective also because of that. The concept of public interest litigation is also a subject of controversy. The court has ruled that where judicial redress is sought in respect of a legal injury or a legal wrong suffered by persons who are unable to approach the court for enforcement of their fundamental rights, any member of the public acting bona fide can approach the court in PIL jurisdiction for enforcement of fundamental right of that person who is socially, economically, or because of other backward class reasons, who is marginalized, that he is not in a position to approach the court of law. He can't have access to the judicial platform, and therefore, for enforcement of that right of that person, the PIL concept was coined. But the rider is that PIL was meant only for enforcement of fundamental rights. Nowadays, the PIL jurisdiction is being expanded to include so many things which were earlier not being looked into as a part of the fundamental rights. And criticism is that what the government was supposed to do, the courts have started doing under the garb of PIL. That is also one of the criticism. They also feel that the PIL jurisdiction is being largely used in a way to derail such kind of policy decisions which a elected government, a popularly elected government takes. So the relative or the contemporary or the second side of the criticism is, they say that instead of allowing the elected people to govern the country, the judiciary has evolved this PIL jurisdiction as a mode to take over some of the administrative or some of the legislative powers, as a result of which, this is what the criticism, that judiciary is crossing the Lakshman Rekha of the separation of powers. That is what ultimately the criticism is. The third criticism is that why are we wasting time in PILs? We are meant conventionally to decide criminal cases. If there is a person who has committed a crime, why we are delaying his conviction? If there is a person who is innocent, who has been subjected to an unfair trial, why you are taking time to acquit him? Because he is languishing in jail. There are civil disputes, there are this dispute, that dispute. So there is a perception in the mind of some people that courts are only meant to resolve criminal or civil disputes, and from where this power has come. But all said and done, all of you know, the power of judicial review, rightly said in Keswanand, rightly said in Indira Gandhi, rightly said in Minerva Mills, and series of judgments. Part of judicial review is a basic structure of the Constitution. Article 226, Article 32 are there, and that power has to be occasionally exercised in a case where the facts and circumstances or the situation demand the conscience of the court pricks, and where the situation is like that, the court must interfere. I think eventually there is no second opinion within the judicial sphere that such a power has to be exercised. And the history will tell that we have been exercising that power, whether it was 1975 emergency or even post emergency, wherever the court felt that yes, there is some kind of, as I would you repeat the word, case of manifest injustice, wherever we have noticed. I think this is one jurisdiction which has given a befitting reply to the state's unconstitutional actions. So before I conclude, I would like to say that the noble ideas of constitutional morality, fundamental rights, due process, and the like that we plan to discuss today are not ideas that come into existence in India only in 1948. That's my strong opinion that I have been sharing it. Let's not think that these suddenly 1946 that our Constituent Assembly was constituted and all these ideas we have suddenly created between 1946 to 1948 and then given effect on 26 January 1950. No, I strongly don't agree with this perception in the mind of some of the people. My own belief is, and I believe that there is a misconception that these ideas were borrowed from the constitutions of other countries. What has only been done is that these provisions, we have only borrowed the craftsmanship of these expressions, that the language, that the terminology, the expressions, because we found that in some of the constitutions, these terminologies or these expressions are tried and tested in those jurisdictions. Those words have been understood in a particular definite manner. And therefore, when the word has a definite understanding on the global map, those words have been incorporated, but not for the purpose of borrowing those ideas, rather for the purpose of translating, incorporating, infusing what has been there in our constitutions. In our constitutions, when I'm talking, I'm constitutions at the time when thousands of years we were being governed by our different regimes. All these you will find in Kautilya, you will find in Smritis, you will find in so many religious and historical books that all these principles were deeply imbibed and embedded in our those cultural ethos and values and those principles under which our kings, our rulers, and those who were to be ruled were governed for generations and for years and for thousands of years. Of course, we lost track, but those very principles with a different kind of terminologies having been coined to address the need of the modern time, those have been incorporated in the constitution. That is my firm belief. And this is how the constitutional morality, constitutional value, constitutionalism has been in a refreshed terminology has been incorporated by our great teams of intellectuals who worked hard for years from 1946 to 48 to give this wonderful constitution to us. Thank you very much. And now that we have two very distinguished speakers with us, I believe that they will throw a light and they will enlighten us on these very critical and very interesting issues. Thank you very much.
Thank you, Your Lordship, for your esteemed guidance and for sharing your valued insights on the present topic. I now humbly request Honorable Shri Justice Chakradhari Sharan Singh, Chief Justice, High Court of Orissa and Patron-in-Chief, Orissa Judicial Academy, to kindly share his valuable insights.
Since we're running short of time, I'm not formally addressing the dignitaries and participants. The three topics of the discussion in session 1 are interwoven. I must compliment the National Judicial Academy for fine-tuning the scope of discussion in session 1. Are the concepts of constitutional trust and cooperative federalism not part of the central topic, evolution of concept of constitutional morality vis-a-vis social morality from the perspective of judicial approach? Constitutional morality in the Indian context can have three perspectives, foremost being the Constitution itself as a living and dynamic document, with the Supreme Court as the final arbiter of constitutional interpretation. The second is from the point of view of legislators and executives. And the third, the citizen's perspective. The concept of constitutional morality has evolved in India by various landmark judicial pronouncements while addressing challenging social and political issues. The concept of constitutional morality, there can be no gainsaying, is at the center of the basic structure doctrine propounded in Keswanand Bharti case. In Manoj Narula versus Union of India, the Constitution bench of Supreme Court, in the background of appointment of Council of Ministers to the Union and the state governments, elaborately addressed the concept of constitutional morality and its role in Indian democracy. Defining the concept, Justice Deepak Mishra said, the principle of constitutional morality basically means to bow down to the norms of the Constitution and not to act in a manner which would become violative of rule of law or reflectable of action in an arbitrary manner. It actually works at the fulcrum and guides as a laser beam in institution building. The traditions and the conventions have to grow to sustain the value of such morality. The democratic values survive and become successful where the people at large and the persons in charge of the institutions are strictly guided by constitutional parameters without paving path of deviancy and the requisite constitutional restraint. The commitment to the Constitution is a facet of constitutional morality. This decision of Supreme Court paved the way for the constitutional courts for testing legislations and actions of the state against constitutional morality and has now become norm of judicial review. In Saira Bano, the Supreme Court held that age-old practice of triple talaq was contrary to the spirit of Constitution and declared it illegal. In case Puttaswamy, Justice D.Y. Chandrachud had given an expensive interpretation to the concept of constitutional morality. In case of Independent Thought versus Union of India, that was relating to sexual intercourse with women above 15 years, the Supreme Court struck down Section 375(2) of the Indian Penal Code. And in case of Indian Young Lawyers Association versus State of Kerala, the ban on entry into Sabrimala temple has been held to be bad, applying constitutional morality doctrine. Morality, the Supreme Court opined, implied constitutional morality, which includes values such as justice, liberty, equality, and that the views expressed by the constitutional courts should be in accordance with constitutional morality. The constitutional morality must be preferred over customary values, the Supreme Court held in Sabrimala, referring to the fundamental rights under Article 25 and 26 of the Constitution. The concept has been further elaborated in case of NCT of Delhi versus Union of India and Navtej Singh. In Navtej Singh, Justice Nariman said, quote, constitutional morality is the soul of the Constitution, which is to be found in the preamble of the Constitution, which declares ideals and aspirations, and it is also found in Part 3 of the Constitution, particularly in respect of those provisions which assure dignity of individual, unquote. The concept of constitutional morality is not limited to mere observance of core principles of constitutionalism, as the magnitude and sweep of constitutional morality is not confined to the provisions and literal text. Rather, It embraces within itself virtues of wide magnitude, such as that of pluralistic and inclusive society, while at the same time adhering to other principles of constitutionalism. In NCT, Delhi, the Supreme Court ruled that constitutional morality, in the strictest sense of the term, implies strict adherence to the constitutional principles as enshrined in various segments of the document. When a country is endowed with a constitution, there is an accompanying promise which stipulates that every member of the country, right from its citizens to the high constitutional functionaries, must idealize the constitutional principle. In Joseph Sain versus Union of India, expanding further the scope of doctrine of constitutional morality while dealing with section 497 of the IPC, the Supreme Court remarked that fundamental rights chapter is like North Star in the universe of the constitutionalism. Constitutional morality always triumphs any imposition of a particular view of social morality by shifting of any majoritarian regimes. In Kantaru Rajavaru, the Supreme Court reiterated that constitutional morality is nothing but the values inculcated by the Constitution, which are contained in the preamble, read with various other parts, in particular parts 3 and part 4 thereof. In a recent judgment in Central Board of Dawoodi Bohra Community case, addressing the question of justiciability of power of Dawoodi Bohra Committee to excommunicate its members, the Supreme Court observed that conscience of our Constitution is the constitutional morality, and therefore the constitutional courts ought not to tolerate anything which takes away the rights and privileges of any person to live with dignity with reference to Article 26B of the Constitution. Electoral bond case is the latest in which 2018 electoral bond scheme came to be struck down, being violative of Article 19(1)(a) of the Constitution. The doctrine of constitutional morality has thus evolved predominantly by judicial pronouncements addressing the legislative and state actions by the judges of the constitutional courts. While preparing for this conference, I came across a brilliant article by Jeremy Waldron, a university professor, Newark University School of Law, on judges as moral reasoners. He framed 3 intriguing questions. Are the judges good at morality? Are they better at moral reasoning than other political decision makers? Is the quality of their moral reasoning a reason for assigning final decisions about the rights to the judiciary rather than to the legislature? This is the criticism, sir, which was being pointed out by Honorable Mr. Justice Shurikant. He has quoted in his article, there are 2 views. Waldron quotes in his article Ronald Dworkin, who says, legislators are subject to pressures that judges are not, and this must count as a reason for supposing that judges are more likely to reach sound conclusions about the rights. And then he quotes Joseph Raz also, who says that there are ample reasons to suspect that the members of the legislature are moved by sectarian interest to such a degree that they are not likely even to attempt to establish what right people have. He called, now what Waldron says, he called the view of Dworkin, Joseph, and philosophers having similar view as judges are good at morality. Judges are good at morality. JGM view. He calls that JGM view. And then he criticizes that the JGM view and says, I said a little while ago that legislative style reasoning is not the same as reasoning by legislature, and judicial style reasoning is not the same as reasoning by a court. It is not inconceivable that courts might use the model of moral reasoning. I have called legislative addressing issues freshly and directly on their moral merits, undistracted by legalism, and that they might turn out to be better at it than legislatures are. However, there are reasons for doubting this. For one thing, the courts have little experience of this sort of moral reasoning, and their own qualms about the legitimacy of their engaging in it are likely to distort what they conduct themselves. For another thing, Warden says, court consists of too few members to ensure that all points of views are aired in the way I associated with the legislative model. Finally, some of the presuppositions of this model, such as representation and the connection between political equality, testing the extent of a view's support, and eventual decision by a majority voting make little sense when applied to courts. What I hope to establish, finally he concludes, what I hope to have established, that this, if we pay proper attention to the sort of moral deliberation that is appropriate for those deciding in the name of a whole society or on outstanding watershed issues of individual and majority rights, the case that can be made for assigning those issues to the courts is by no means compelling. At any rate, the thesis we have called JGM has been shown to be non-starter. This is the view of Walden. Walden's view gives us enough food for thought. I have not formed any opinion. I have given to the way the concept of constitutional morality has evolved here in India, and the view of a scholar, Walden. I conclude with my opinion that the spirit and the constitutional conscience lie in the preamble of the Constitution, Part 4 of the Constitution, which lays down fundamental principles in governance of the country and casts a duty upon state to apply those principles in the governance of the state, and Part 4A, which casts duties on every citizen of India, which need to be promoted by constitutional methods. Thank you. Thank you so much.
Thank you, Your Lordship, for your enriching insights and cherished guidance in this regional conference. I now humbly request Shri N. Venkataraman, the esteemed Additional Solicitor General of India, to kindly share his valuable insights. So please.
Honorable Justice Suryakanji, Honorable Justice Amanullah sir, Honorable Justice Aniruddha Bose, Honorable Chief Justice Chakradari Charan Singh, Honorable Judges of the various High Courts, and young judicial officers, and our lovable NJA, which provides the opportunity periodically to people like us. We will take two concepts today, the next 20 minutes, 10 minutes on each one of them. And what is cooperative federalism? The core essence of cooperative federalism in our constitution. What's the theme of our constitution on cooperative federalism? And what do we actually mean by constitutional morality as an evolving doctrine, a fast growing evolving doctrine? When it comes to cooperative federalism, you can say there is something to speak about it from the Constitution itself. And the recent judgment rendered in Article 370 is a defining moment in identifying the basic elements or components which go to contribute to the doctrine of cooperative federalism. This constitutional bench judgment rendered in 370 for the first time brings out the clear distinction between legislative rights, legislative powers, vis-a-vis sovereign powers. Because there is always, sovereignty and federalism are two distinct concepts, which this judgment seeks to advise us, express its opinion. And it also makes a distinction between the right to legislate under the Constitution is distinct from enjoying sovereignty over the Constitution. So what is this distinct? Because this is the edifice on which somebody can build cooperative federalism in a nation which is so vast, in a nation which has different sets of rights and liberties and duties by the states, which are the embodiments which actually make the Constitution. But this judgment very clearly says, nation breeds itself through the architecture of the states. But yet, nation is distinct from states. In terms of the constitutional designs, in terms of external affairs, in terms of currency, in terms of a Supreme Court, in terms of an IAS cadre. So, they are distinct clusters assembled within the same book doctrine of the Constitution. Now, the distinction between a sovereign power and a legislative power, if we find them to be subtle and distinct, then climbing the next few steps will be very, very easy. So the court says, no doubt, union has certain set of legislative powers and state has certain set of legislative powers. The fact that entry 97 of the list 1, which embodies the power of residual powers, and in the erstwhile JK constitution, the residual powers was with JK. Residual power to legislate is not equivalent to residual sovereignty. That's the evolution which this judgment seeks to portray. One may have the domain left either to the states or to the center in terms of legislative powers. Residual legislative power does not signify or mean or is equivalent to residual sovereignty. That's the first principle. Why? Because the sovereignty under the Constitution neither rests with the union nor with the states. It rests ultimately with the people. So one end of the spectrum, it is the people. The other end of the spectrum is what governs ultimately or guides us as people of this nation is the Constitution. It's not any one of the particular organ. So the top of the pyramid, it is the Constitution. And the location of the sovereign power is with the people. So the judgment makes it clear, it is not as though the state derives any of its power either from the center or from the parliament. It derives its power only from the Constitution. So it therefore moves into the next critical step of understanding when it comes to inter se relationship between the states and the union. What is the connecting bridge? And it says the connecting bridge should always be and only be through the Constitution and nothing else. So building a relationship, strengthening relationship is an active choice which can be found, discovered, excavated, explored, explained only through the lens of the Constitution and nothing else. So, distinction between rights, right to legislate and sovereignty, the distinction between flow of power from the Constitution and the connecting inter-se relationship should only be through the Constitution, should be the first foundational pillars of building a cooperative federalism process. Why do they say so? This judgment, the constitutional bench judgment, also seeks to discuss further. Federalism in India is both symmetric and also asymmetric. And it discusses various articles in the Constitution to come to this conclusion. What is symmetric federalism and what is asymmetric federalism? Symmetric federalism is this is all because of Part A, Part B, Part 3 state. That's a legacy behind it. So, where states are aligned completely with the Constitution in its scope, in its tenor, in its rights, in its caste, then you call those states as symmetric federalism. Where special rights are granted to states, whether it's Northeast or whether it's Andhra Pradesh, there are, if you see Article 371 series, you will find special status being given to certain states. Those states, the federal structure there is asymmetrical because all those states do not enjoy the same rights. They are given to ensure balance, equities. Now, therefore, this judgment says, whether it is Article 370 or 371, they are only varying degrees of asymmetric federalism and nothing beyond that. There is nothing called, it doesn't go and crack the principle or the doors or the rocks of sovereignty. That lies only with the people. It can only travel in understanding legislative powers, in understanding to what extent it is symmetrical or asymmetrical. But it will still fall only within the sphere of federalism and nothing beyond that. So it has virtually aligned the states to the mode of either it will be symmetrical or asymmetrical, but both are essential ultimately in cooperative federalism. So with this background, let's see one complete, very, very fulfilling and an objective which is working well, at least for the past 7 years. The architecture of the GST Council through Article 279 is the hallmark of our Constitution on cooperative federalism. Something which everybody thought may not happen at all because it is a 25-year experiment. It did not happen just overnight, but 22 years people have worked, states have worked, finance ministers have worked. And finally, the critical moment happened on 1/7/2017. GST Council is one perfect constitutional body embedded on the principle of cooperative federalism. And how do we say so? These are all principles found in 279A and found in 246A. See, right from the beginning, we had a direct taxation through income tax, which was a parliamentary levy or a union levy. Whereas indirect taxes, it got divided into two. When it comes to import duties, manufacturing duties, excise duties, service tax, it was the domain of the union. When it came to sale of goods, it became the domain of the states, but for the interstate purchase and sale. So you had 10 different levies. Your invoice will have only one line item of the article, but 10 line items for the taxes. This was the era in which we have all gone through. Now, an understanding entered into between states and the union to subsume. What do you mean by subsume is both parties trying to yield to the other. States were willing to integrate their sales tax into the common pool. the union was willing to integrate excise duty and service tax into the common pool. And this is how 246A reads today. It says, we will choose one event as a taxable event instead of excise duty, sales tax, additional excise duty, X, Y, Z, service tax. We will choose one event, both of us together. And the union and states chose supply of goods and services to be the taxable event. So one event is the first starting point, with both the federal partners getting equal right to tax. If it is going to be an 18% tax, union will get 9 and states will get 9. So one taxable event, two federal partners taxing it at the same time, and most importantly, there are of course some more articles in the Constitution. You will our constitutional judgments are very clearly said, lists in the entries are only fields. You will not find a field of legislation for GST in list 1, list 2 or list 3. GST is not a concurrent levy, it is a simultaneous levy. That's the difference. In concurrence, you will have to undergo the constitutional test of repugnancy under Article 254. Whereas GST doesn't undergo this. It is a simultaneous, both partners levy it at the same time. And therefore, there is no Schedule 4 or List 4 in the Constitution. The very activity, the field of legislation is also embedded in Article 246E. It's a beautiful architecture. You not only have the supply event being embedded, you also embed the field, goods and services, into the article itself. For example, citizenship, you embed it in the article itself. There are several such articles in the Constitution. It's not so unique, but you don't have, therefore, it is not concurrence, it is simultaneous. Now, how do you decide matters? This is very, very important. And Supreme Court, 3 judges in Mohit Minerals, in which Honorable Justice Surikant was also one of the judges in the three bench, have delivered a unanimous verdict. See, why we say it's a moment of triumph for us. It's a claim of pride which the nation can make to showcase that we are an evolved democracy. It is the GST Council which becomes the recommending body both to the union and to the states. Every decision has to now flow only through the GST Council. And now that we are privy and we work with the government, the kind of architecture that gets, the back-end architecture that gets prepared before a GST Council meeting happens actually. How the finance ministers meet earlier, how the revenue secretaries meet earlier, how the equal partners discuss, how the fitment committee reviews states' priorities. It has a design in it. So once, and 99.5% of the decisions in these 7 years has been unanimous. That's one more achievement of cooperative federalism. So how does this succeed? The bottom line is simple. This is not about water. It's not about rivers. It's not about forests. It is about trade and business, which is vital for every state. And therefore, we are now in a situation, one state cannot say, I'll pull out of it and I'll tax it at my choice. That state will get isolated from the scene. So everyone has to work together. You will have to have a uniform taxation regime. And this is achieved through the GST Council. So this is where we stand in the evolution of cooperative federalism. Now coming to the constitutional morality aspect. It's a very, very interesting dimension, a very powerful doctrine, we should say. And still, 2 strong opposing schools of thought exist when it comes to constitutional morality. 2 completely strong opposed schools. One approving endorsing the doctrine, another completely opposing the doctrine. Now the reason is this. See, when does morality actually come into the scene in our lives? It's the same way it also comes into the Constitution. Whenever you have rights and duties to perform, either as an individual or as an institution. Whenever there is rights and duties, there will always be an underlying morality in exercising of that rights and duties. This is the seed. Because rights and duties are enforceable, whereas morality is something to be pursued and not enforceable. So there will always be an underlying morality. The same principle applies also to our constitution, because constitution conceives rights and duties. When you conceive rights and duties in such a massive document, then it also obligates that there has to be a window for constitutional morality. Now, how is this architectured? Through, it is felt more through judgments. You will not find you will find the word morality in the preamble or in Article 25, in Article 6. There are several places in which, but you will not find that very word constitutional morality. It's a theme coined by our courts, starting from Dr. Ambedkar in the Constitutional Assembly. It's evolved over a period of time. See, there are three important principles. When it comes to constitutional authorities and people holding responsible positions, delivering service to the society, the constitutional benchmarks them under the principle called constitutional trust. Every constitutional authority works under the principle or doctrine constitution, that constitution trusts that authority for doing that job. When it comes to the individual citizens, the constitution expects that to be a constitutional morality. Now, that is why this is a very powerful dimension and a contested dimension. What is the connecting bridge between constitutional morality and constitutional trust is constitutional silence. That's what our judgments say. When constitution is silent, it is potentially vibrant. That's the commentaries which explain it. Because you cannot foresee everything for the next 300 years. It's not possible. Therefore, one school of thought very clearly calibrates this doctrine by saying, look here, whether it is constitutional trust or a constitutional morality, this should emanate more out of self-restraint, self-discipline. This is expected of and therefore should be thrusted through self-restraint. Especially when you exercise power, discretion, or authority. The evolving school says, this is acceptable to us, no problem about it. But when authorities start to breach constitutional norms, then there is a breach of the trust. Nice. I'm so sorry you're forced to listen to me, sir, today. So, the two opposing schools are only the clash of the points is only on it materializes only on one aspect of it. When you will call, sometimes you call constitutional silence also as constitutional vacuum. Sometimes you call constitutional morality as a constitutional convention. These are all terminologies used by judgment under a different context. But the underlying principle is self-reliance is the first code. And when you breach self-reliance, then you will necessarily have to put it into a doctrinal approach through a judgment. And that is how constitutional morality is slowly evolving itself into this domain space as part of the constitutional literature. But The opposing school authors and the commentators very clearly say, see, this is our opposition. And you must understand, when you interpret a law, including the Constitution, you should have an objective criteria. So the question they pose is, does morality have an objective criteria? So when elements of subjectivity influence your decision-making process as a constitutional authority, the judgments that get pronounced on the principles of constitutional authority will have multifaceted, pluralistic views and need not necessarily be very uniform or consistent. This is one opposition to constitutional morality by one school of thought. One is subjectivity and not objective. Two, uncertainty. And three, proportionality or disproportionality to the cause that gets vindicated. So these are the three basic objections by one school of thought when we evolve this principle of constitutional morality. So in this given time of 20 minutes, we thought we could share on two basic concepts. One is cooperative federalism and another is this constitutional morality. The only request for, there are so many young officers, as you evolve, as you see so many things in your life, as you do the matters in the years to come. Though the constitutional bench in Article 370 says nation is found through the structure of states, it also does say very clearly nation is distinct from states. And the paramateria consideration for a nation in terms of several priorities in the Constitution are extremely very, very unique. So we will be impacted by our ideologies, we will be impacted by our views in whatever form we contribute to the ultimate thesis. But viewing federalistic views, understanding and delivering judgments on federalism, should it be government-centric or nation versus state-centric, is something which I will leave it to this august audience to bear it in mind. See, if it is going to be government-centric, then it will serve short-term objectives, no doubt about it, because we react to the pulses of the present situation. But whether it will vindicate the long-term goals is something which we don't know. So, but nations and states will continue to exist beyond us. So, a longer vision analysis on this very, very sensitive subject of federalism is better we pursue it as nation versus state rather than government versus government. Thank you so much for this opportunity.
Thank you, sir, for sharing your invaluable expertise, your legal acumen, and your kind participation in this session. Before we end this session, we take this opportunity to felicitate the esteemed and honored speakers of this session as a mark of our immense reverence and gratitude. For this, I humbly request Honorable Shri Justice Sangam Kumar Sahu, Judge, High Court of Orissa, and Chairman, Judicial Academy and Training Committee, High Court of Orissa, to kindly adorn the Uttariya and present the memento to Honorable Shri Justice Chakradhari Sharan Singh, Chief Justice, High Court of Orissa, and Patron-in-Chief, Odisha Judicial Academy. Thank you, Your Lordships. I now humbly request Honorable Shri Justice Anand Chandra Behra, Judge, High Court of Orissa, and Member, Judicial Academy and Training Committee, High Court of Orissa, to kindly adorn the Uttariya and present the memento to Shri N. Venkataraman, the esteemed Additional Solicitor General of India. Thank you. With this, we have now come to the end of this first session. We now have a short break for tea. We request all the honored dignitaries and esteemed participants to kindly reassemble here shortly for the commencement of the next session. Thank you. We request everyone to kindly reassemble here before 12:15 for the commencement of the second session. Thank you. Of this East Zone 1 Regional Conference on Contemporary Judicial Developments and Strengthening Justice through Law and Technology. We are awaiting the arrival of our honored dignitaries.
Let's start.
Start.
All judicial officers are here, or they are coming.
Judicial officers are here.
All.
We now begin with the second session. This session is on elements of judicial behavior with focus on ethical standards, judicial norms and conduct of judges, objectivity in decision making, integrity and impartiality to ensure judicial neutrality, communication skills, and ethical conundrums in judicial sphere and their possible outcomes. As the speakers for this session, we are delighted and beyond honored to have with us Honorable Shri Justice Abhay Srinivas Oak, Judge, Supreme Court of India, and Honorable Mr. Justice Ehsanuddin Amanullah, Judge, Supreme Court of India. Before we begin with this session, when we plant a sapling, two things grow for a better world, a tree and humanity. So, I request Judicial Officer Ms. Debasmita to kindly present Honorable Shri Justice Abhay Srinivas Oak, Judge, Supreme Court of India, with a sapling. Thank you. May I now humbly request Honorable Shri Justice Abhay Srinivas Oak, Judge, Supreme Court of India, to kindly address the gathering in this session. Your Lordship, please.
Good morning, esteemed sister and brother judges of various high courts, my esteemed brother Justice Amanullah, the Chief Justice of the High Court, Justice Aniruddha Bose, Director of National Judicial Academy, and judicial officers who are present here. At the last minute, I decided to change the order of our address. Normally, my brother would have addressed first. But I realized that I can use my seniority because I found that brother is far more better speaker than me and far more colorful also. So I thought that I should speak first and then allow my brother to take over. Judicial ethics is a subject on which we can endlessly go on talking. I remember my first day as a judge of the Bombay High Court, though I was sworn in on 29th of August 2003. Since it was a Friday, I sat on 1st of September 2003 with one of our greatest Chief Justice, Justice C.K. Thakkar, who later on became judge of the Apex Court. Till my elevation, every day, I used to appear before him at least 8 to 10 matters. So I was very confident that I thought that it will be very easy. When within first 5 minutes after sitting on the dais, I realized that I will have to make a fresh beginning in the sense that judgeship is completely different ball game. And then, several doubts used to come to me. First day itself, a very dear friend of mine with whom I shared a table in our barroom. So I wondered whether I should hear the matter of my friend. So I was so grateful that on every Friday in the evening, Justice C.K. Thakkar used to virtually conduct coaching class for me on judicial ethics, and I was immensely benefited by that. I always believe that those who hold judicial posts must follow the highest standards of rules of ethics. I firmly believe, and I have said so on public platforms during the last 10 years on repeated number of occasions, that today our judiciary is facing crisis of credibility. When we go back to masses, when we go back to the society, you will realize that the litigants, the common man, doesn't carry exactly good image about the judicial system in general. All of us, I'm not saying only judges of our trial courts and taluka courts, but all of us will have to do something different to improve our credibility in the minds of common man. One is to follow very high ethical standards. That is one of the methods by which we can give back the glory to the judiciary which existed, say, about 20 years back, 25 years back. In fact, you look at the concept of judicial ethics. It is not rocket science. It's very simple. It's common sense. Ultimately, if you think in a simple form, what consists of judicial ethics? One is a fair behavior, fairness. Now, fairness, fair behavior with the litigants, the lawyers, the colleagues, junior colleagues, your senior colleagues. While dealing with all these stakeholders in the judiciary, your conduct has to be very fair. Integrity and honesty are the basic virtues. One of the brilliant teachers who was teaching me law of contracts in Government Law College in Mumbai, he still continues to teach at the age of 84 also. He used to always tell us that, look, honesty is not a virtue, dishonesty is the vice. And when you are part of the legal system, integrity and honesty, which is something which is basic, we need not dwell upon it. One of the most important parts of judicial ethics is absolute commitment to the cause of justice and constitutional values. What is constitutional morality, etc., has been discussed in the morning session. But I always believe that commitment to the cause of justice always includes commitment to the constitutional values. All of us know what are those basic values: justice, liberty, equality, fraternity, and secularism. One more very important part of ethics is that judge has to be honest when he decides a case. The formula is very simple. You hear patiently, understand intricacies of the case, both factual and legal. Think about it, come to the conclusion. Before you pen down your judgment, test your conclusions yourself, make some introspection, and then decide. And once you come to the conclusion that this is the way you are going to decide, do not bother what higher court is going to say about your judgment, what your colleagues are going to say about your judgment, what the members of the bar are going to say about your judgment, what media is going to say about your judgment. This is the honest way of deciding a case. But what is important is thorough application of mind, and one more safeguard: when you come to a conclusion, test your conclusion again and again, make introspection. And then once you come to the conclusion, never ever bother about what others are going to say about your judgment. And I say so especially in criminal matters or bail matters. If after hearing a case, a bail application, you come to the conclusion that the accused deserves to be enlarged on bail, nothing should deter you from granting bail. It may be a very sensitive case, say a murder case at local level, which is very sensitive. But if you come to the conclusion that accused deserves to be granted bail, you must grant him bail. Don't bother what media is going to say, what Twitter is going to say. And even I'll go to this extent, what your registry of the High Court is going to say. The reason is that we have concept of liberty under our constitution. Maybe some special laws, keeping aside special laws like PMLA or UAPA, still the golden rule which was taught to us by Justice Krishna Iyer prevails. Bail is the rule and jail is the exception. Therefore, please remember one thing: honesty in your judicial decisions is very essential part of ethics. If your decision making is influenced by external factors, like what will happen to my promotion, whether somebody sitting in the High Court will transfer me to another place, I don't think these should be considerations when you decide a case. Take a case of criminal trial. What ethics requires to do is to decide strictly in accordance with law. If you find that it's a case of no evidence, or it's a case where benefit of the doubt has to be given to the accused, you must give benefit of the doubt to the accused without bothering about the consequences. Because ultimately, liberty is one of the most important constitutional values. Liberty is protected by one of the most important articles of the Constitution, Article 21. So this part of the judging is very essential part of the ethics. I was delivering a lecture before a judicial academy, and I follow one consistent practice that after my address is over, I always have interactive session. And I always tell the judicial officers, even when I used to deliver a lecture in my state of Karnataka, I used to tell the judicial officer same thing, that ask me free and frank questions. Those questions will not be reported to the registrars of the High Court, and even if by chance registrars are sitting, they'll close their ears. So one of the district judges asked me this question. He said, sir, sometimes it so happens that after the entire evidence is adduced in a case, it may be a case of violence against women, it may be a case of 302, it may be a case of 306. Sorry, I'm referring to old sections because I'm not conversant with new sections. So pardon me for that. The judge said, young judicial officer was direct appointee from the bar as a session judge. Sometimes I feel that though the evidence is not adequate to point out at the guilt of the accused, I find that I get convinced that this man must have committed an offense. And therefore, I am tempted to convict an accused. Maybe I said it a bit harshly, but I told him that this is judicial dishonesty. How do you come to the conclusion that this accused has committed an offense? You may believe, maybe by your sixth sense, or maybe by your experience, or maybe you may be a student of psychology, that perhaps this man must have committed this. As a judge, the judicial ethics does not permit you to go into this area and imagine whether accused has committed an offense. As a judge, judicial ethics requires you to see the evidence adduced by the prosecution, apply the test of burden of proof which is warranted by the particular statute. If burden is fully on the prosecution, apply your judicial mind, apply the existing law and decide whether the burden has been discharged by the prosecution. And if you are convinced that burden has been discharged by the prosecution, or sometimes the burden is on the accused, for example, where section 106 of the Evidence Act is applicable, the accused has not discharged the burden, then come to the conclusion. If you are not convinced that burden has been discharged by the prosecution, there is no other way but to acquit the accused. If you deliver moral conviction, that is completely unethical. Completely unethical in the sense that ultimately you are sitting there to discharge your duty in accordance with law. And every law finds support in the Constitution, the constitutional principles. And therefore, if you decide to convict a person in absence of legal evidence, this is complete violation of Code of Judicial Ethics. So please remember this. There is one more area where I need to address you, which is essential part of the judicial ethics. there is one principle that justice should not only be done, but it should be manifestly seen to be done. And that's very important. And that is where your conduct comes into picture. Where we commit breach of this principle, there are several instances. I'm deliberately saying we because I may be also guilty of transgressing the limits of judicial ethics in my long judicial career. As a lawyer, I experienced this. When a senior lawyer appears before a judge, sometimes I used to get an impression that he gets a favorable treatment. Or sometimes one gets an impression judges get bogged down. This is the worst thing to do, is to favor a senior, or at least nobody should be under impression that you are favoring a senior. I remember as a lawyer in the High Court where I used to practice, some senior lawyer used to come from Delhi, and I have seen very sad spectacle when there are 100 matters on the cause list. The judge seeing at the lawyer and asking me, "Sir, what brings you here? What is your serial number?" We as lawyers used to get hurt. I mean, why this special treatment from somebody who comes from Delhi? And this is how we learn. So in my court, I never gave that treatment. A lawyer, somebody used to mention before me in Bombay or in Karnataka, "Sir, so-and-so from Delhi is coming. Please give a particular date." I used to tell them, "Look, man sitting in Delhi can't control my cause list. Ultimately, I will decide my calendar." This gives wrong signal. A city like Bombay, in magistrates court, many distinguished lawyers from all over India appear. I used to always tell my judicial magistrates, don't give priority. Don't give priority because somebody comes from Delhi or somebody is very senior. Don't give priority. You give priority to that case only if on facts that case deserves to be given priority. And I used to always explain to them that I was guardian judge of this courts in Mumbai for a long time. I always used to explain to them that, look, somebody comes to Delhi, he is paid for that. He is not obliging you by coming to your court. We don't know how much fee he is charging, but he is paid to come to a court in Bombay, to sit in the court and patiently wait for his turn to come. So this is very important part of judicial ethics is never favor anybody. And at least from your conduct, it should not be seen that you are favoring anybody. Here lies a bit of a problem. I always believe when very senior member of the bar appears before you, you have to respect seniority in the sense that, in judicial hierarchy, whether you are a part of the judiciary or you are part of the bar, seniority always has to be respected. To some extent, yes. As a judge, you are discharging your duty, some very eminent senior advocate appears. Seniority has to be respected, but it must end there. And this balance is very difficult. It's a very delicate balance to maintain. But you have to learn and maintain that balance. Therefore, favoring some lawyer only because of his seniority is totally inconsistent with judicial ethics. There is one more area where we face that every day. In the trial courts, in our district courts, we face that problem every day. We face that in high courts also. Why not high court? In Supreme Court also. Now there is a new trend that there are cantankerous lawyers who will come to the court, who will create a scene, who will make allegations against you. You must remember one thing. Why they do it? Their only object is to browbeat you and to compel you to pass a wrong order. I have seen cases after cases. It happens in every court that a cantankerous lawyer appears, he creates a scene, he browbeats you, he will say that you are doing great injustice. And then sometimes we are all human beings. Then sometimes we end up in granting interim relief in such a matter which does not deserve. It is both ways. I have seen the other extreme also. Sometimes we get affected by that browbeating or that aggressive conduct in the court, we grant relief. Sometimes we go to the other extreme. In our mind, of course, we study the lawyers. We know that A lawyer is very reliable, B lawyer is very fair, and C lawyer is very cantankerous. D lawyer will always mislead you. So you have that impression about some lawyers that this lawyer is mischievous, he is not reliable. And then only because the lawyer is mischievous or not reliable, we sometimes end up in passing order against the client of that lawyer. This is where we commit mistake. Therefore, I always tell the young judges, I've been teaching in all judicial academies for the last 15 years, that as judges, if you want to maintain your code of ethics, you must learn one art of looking through the lawyer and looking at the client, because you are sitting there for the benefit of client. You have to see the conduct of the client. You have to see the case on merits of the client. We should not bother about the conduct of the lawyer. But there are cases and cases where cantankerous lawyer or a lawyer is infamous for misleading the court. His client may have a very good case, but somehow after all, we are all human beings. Sometimes we simply go by the lawyer and we simply say that no relief. So while dealing with such aggressive lawyers, we have to take the correct path. And we have to remember that ultimately we sit there to uphold the cause of justice. Ignore the lawyers who appear and then decide justice lies on whose side. There's one more area where I'm talking about my colleagues in the district and trial courts. In every judicial academy today, time is short, I'm not saying that. I always maintain that the most important courts in our country are our trial courts and district courts. Unfortunately, for years together, 75 years after Constitution came into existence, we give importance only to our constitutional courts, because our trial courts and district courts or sessions courts are the courts of common man. Very few afford to go to High Court and fewer afford to go to Supreme Court. Now, therefore, my piece of advice to judicial officers is that never get bogged down because of the tactics adopted by cantankerous lawyers. And what you need to develop is judicial craftsmanship. It's an art which can be developed by practice. See, ultimately, one principle you must always remember, that never lose your patience in the court. Never get angry in the court. You must maintain cool, because in one case, if you get angry in the morning when you sit in the court, that will affect your decision making for the whole day. We had a very eminent judge, a retired judge. After I was elevated, he was retired judge of the Bombay High Court. I had seen him practicing. I had appeared before him. So I thought that I'll go and seek his blessing and advice. So he gave me a very important piece of advice. Perhaps due to my demeanor and my conduct in the bar, everybody had an impression that I'm too mild a person for judgeship. So he said, please remember, I know that you will not get angry. You will not get impatient. And he said, never get angry. But he also said that maybe once in a fortnight or once in a month, you have to give signals to the members of the bar that you are not a soft person. And therefore, in some case where lawyer commits default, lawyer misbehaves, you decide in your mind, now I want to show that I am angry. And then take that lawyer left, right, center once in a month or once in a fortnight. Because if you don't do that, the lawyers will feel that you are too mild and you are taking it lying down. But the crux of the matter is never get angry in the court. But ultimately, judgeship is also an art. Unlike other arts, we can perfect that art by practice and by analyzing the human mind, by analyzing the lawyers, by analyzing the litigants. And therefore, this is an art of judgeship. that how do you deal with lawyers? And therefore, I always say that while you are bound by the rules of ethics, that no favoritism, nothing, but you must always study the lawyers who appear before you. You are going to be at one station in most of the states of practices. When you are posted at one station, you're there for 3 years. So start studying the lawyers and then decide how we are going to deal with a particular lawyer, how we are going to deal with the adjournment masters. So that is all part of art of judgeship. And that is all about judicial craftsmanship. There are once I was delivering such lecture, one judicial officer asked me, recently appointed judicial officer asked me a question. That, sir, sometimes it is very difficult to point out that a senior lawyer is wrong or his conduct is wrong. He gave me an example. There was one senior lawyer who was practicing before him. Whenever he used to record cross-examination of the witness examined by that senior lawyer, after every question is asked by the cross-examiner, he would get up and raise an objection. He said, he's so senior, then how do I deal with him? So I gave a different piece of advice. I said, you must muster courage to tell that lawyer that this is not done. But I said, you'll get opportunity. There may be a case where not that senior lawyer will be sitting in the court. And the other lawyer who is cross-examining may be indulging in the same practice. So there is say in Marathi, which I translated in English. In what happens, it said in Marathi that there is a new daughter-in-law in house. So the mother-in-law hesitates to criticize the daughter-in-law, but instead of telling something which she wants to tell to the daughter-in-law, she tells her to her daughter. So that is how give signals in the court. If you don't want, you are not able to tackle a senior lawyer, somebody else is doing that, tell him, sir, this is not done. See, ultimately, if you want to uphold the principles of ethics, what you have to do is develop judicial skills, judicial craftsmanship. And the most essential part of ethics, which rules of ethics you must follow, that you must become a strong judge and most importantly, a fearless judge. These are the few things which I wanted to share with all of you. Now I request my colleague to take over. And again, one more request to all of you, including brothers and sister judges here, that please feel free to ask any question you like on the subject. Thank you for patient hearing. Thank you.
Thank you, Your Lordship, for your insightful guidance, your enlightening words of wisdom, and for highlighting the importance of upholding high ethical standards and maintaining judicial impartiality in our decisions. May I now humbly request Honorable Mr. Justice Ehsanuddin Amanullah, Judge, Supreme Court of India, to kindly address the gathering in this session.
Thank you. Once again, a very good afternoon to all of you. My very esteemed and dear senior colleague, Justice Oak, Justice Chakradhari, Chief Justice, Orissa High Court, and Justice Anirudh Bose, brother, sister judges, members of the judiciary. It couldn't have been better place than what we have heard from Justice Oak. He has gone into all facets and such clarity and simple language. I think everybody must have understood the import. And I think whatever he has said from experience. That is the difference it makes. Many ethics seems to be a very easy thing for everybody to speak on. People say, what is ethics? Very common. We don't generally give too much of importance. Everybody knows just has to be honest, impartial, what is there. But it's very difficult to follow the standards which is required, and has rightly been indicated that now we think that it is a charity we are giving to the institution if we are patient, and if we are fair. Integrity is a very big thing. You carry a badge as if you have achieved something. All these are basics are never to be discussed. Why today, even after 75 years of independence, over 75 years of independence, very fiercely independent judiciary as we are perceived in the world, and rightly so, touchwood, we are. Why all these things, ethics? Why does it still remain the core issue which we are not being able to handle properly? I think I'm very confident. It's a personal view. People may have a different take on that. But somehow we have slipped on a basic concept of how the judiciary should behave, both from the bar side and from the side of the judges. There's suddenly been, the gap has increased as if there are two distinct levels and one standard applies and a different standard applies in each and everything, and we have an upper hand. Without being discourteous or disrespectful for anybody, I think the onus is more on judges, because as we all know, we are in control of our courts. It is our responsibility, not the responsibility of the counsel or the client or our staff, court staff. It is us ultimately who is responsible for whatever we do. And again, quoting from Sir, that justice should not only be done, it should be manifestly seem to be done also. These are very old, hackneyed words. Now, how do you seem that what is the meaning of seem to be done? These small things count when your conduct in court is concerned. How does the client or the advocate get the confidence that, look, I am standing before a court or a person who has absolutely nothing in mind, clean slate. He's not bothered who my opponent is, senior, junior. I am there, I'll place my facts, and he will decide in accordance with law, not with regard to his personal biases, perceptions he carries. Sometimes there's a dharam sankat, which we call common word. And it happens because we are human beings. We are emotional, we are sentimental. We live in a society. We are not isolated from anybody. But then how do you deliver? And you can't say that because this is my compulsion, I cannot. Then probably you did not do your duty correctly when you said yes for becoming a judge. You should have thought of your frailties and your capacity to overcome them. You don't have that excuse to say, oh, this is natural, I can't help it, nobody does it, why I? There's no comparison among anybody. Straight away we start comparing, oh, all this, everybody does it, this is a common trend. This lawyer, his country, he has to be taught a lesson, and this is this. Why do we become judgmental from before? Ultimately, without any basis in the end, it's your perception. Where does perception come in the factoring of delivery justice system? Surmises, facts. As lawyers, we used to argue it's only based on surmises, prejudices. What does it not apply when we are on the other side? It applies with more force. We have to be very careful of how we perceive. I'll give you small examples, especially at district level. Again, taking the cue from my senior colleague. When out of that, they'll give their inputs. The High Court, I used to go, love to appear before the law. Sometimes you have judges who will just hear without even noting your citations. You know that he's not hearing. It's only he's being patient because you've come, he doesn't have any job. Is that hearing? Are you being ethical? Are you being true to your uh, character which is required of a judge? Absolutely not. It's a fact you're wasting both time, of his time, your time also. What does hearing mean? Small, small things. These are things which will instill confidence. You know, in high courts, we had judges, I'll not take names, my Patna colleagues are here, very conservative, dismissal court, patient hearing. Nobody is aggrieved. Ultimately, everybody wants that what you are saying, he takes notice, he interacts a little bit with you, he shows that he's trying to understand. Doing a duty, unpleasant duty of having to hear the other side. Not hearing. The basic principle to hear. You case, I'm giving common example. You read a case 10 times, that is 10 times. I think at least 5 times you'll feel that something new you also understood. Every day it happens that I come and I feel suddenly some lawyer has said something during the day, even till now. I had not thought of that that angle, that aspect. That is the beauty of the system. Why has our laws stood the test of time? Because there's so much of dynamism, people can explain situations, fit into that. That otherwise laws would have changed every 2-3 years had they been so straight in a jacket, straight jacket. But it's not. This that it is so dynamic, open to interpretation that it has stood the test of time, continued, and still it is good as it was 75 years or 80 years or even 100 years back. But then we have to understand, we have to understand that the goodness is not because of that. It is also because law has left many things to the discretion, objective discretion, unbiased, unfavorable, decision of the interpreter. You are the one who have to be, but then you have to give both the sides chance to try to tell you, look here, this is also an aspect. Please listen to me. No, law is well settled. Especially in the Supreme Court, this decision, that decision. I never go by these decisions. First, we have to understand, just little bit patient. I know in the Supreme Court now, we have taken a decision to give a little bit more of hearing. I remember when we used to come, by the time we finished our second point, no chance of any third point. Now I think we have become more liberal in giving them more opportunities in the Supreme Court also. But that is what is ultimately required of you. The objectivity in making decisions is one of the sub bullet points. Integrity, impartiality to ensure very difficult, so wide meaning, and rightly again, it will take days to even touch one aspect of that, because there's so much to be clarified, so much to be looked up to, especially in the persons who are freshly appointed to the judiciary. One thing with a note of caution I'm marking, suddenly there's a trend of overconfidence in the new person, in the new recruits. They think I've come with the National Law School 5 year. I know my peers, people who are the ADJ. There's nothing like time which The world doesn't know. The entire world knows you are. This is the beauty of our system. This transparency is so much these days. You can't hide. And why to hide if there's nothing to hide? You should be the first one. It should be an open book. So there's no need to hide from certain things or to be inhibited. You should not be bothered about the consequences. Many a times I hear among judges also, and it is slightly unfortunate and depressing. And you know, I'm very outspoken. Sometimes my colleagues catch my hand and say, don't say all this. My family says, why are you so vocal about it? I don't feel compulsion. Is there that a consideration? No, you have to think of the larger. What is this larger? Law has been made parliament. It's a constitutional framework. You may feel something, but that feeling doesn't come. You have to feel the pulse of the law, not the feel of the pulse of the media or the feel of the pulse of the society. Somebody has to be made a scapegoat. You know. And then you don't have to bother about the media, what people think. I don't know how many times I have been told what has been said. We don't even bother. I'm not on any social media. Why? Get bothered about all that. All that tension and time if you spend on your work, you'll become a far better judge. So, but yes, you cannot factor that out. And I'll tell you, the moment you joined the profession or you accepted judgeship, you knew what was in it. You knew that your family would suffer socially in the sense that now you would not be having that free access to all functions, do whatever you want, there would be restrictions. But I'm sure when you join the judiciary, you do it at a very mature age. You cannot say, I didn't know about this, I didn't know would happen. If you didn't know, then it's your fault. Nobody forced judgeship on you, especially the persons you competed, you pushed out others. And now you can't say, no, this is not. Suffer. Every judge, I can vouch for that. Every judge of the High Court and the Supreme Court, some relatives, they have expectations. From your friends, they have expectations. From the societies, they don't understand our compulsions. A bureaucrat was telling me, sir, you all say this, we do this, but you all don't accommodate. I said, you are under misconception. The misconception is that you have a discretion. Somebody might put in a word, you have 10 people, 10 places posted. You have discretion who will be. Somebody would say, kindly, if you can put him here. So that is the discretion. It is not illegal. But if you tell me to do this in a case which is illegal, I will not be able to do it. They don't understand. They can't understand because they don't have that capacity to understand. They say, no, you are a case, you write a judgment. How do you get over that? It is a difficult job. But then your first signals do matter. The very first signal, at the first time, if you fail, you'll not be able to control. Your close friends whom you've been dining, living together, having family terms, they are your colleagues in profession. They would be the first ones you'll have to give the correct signal that, look here, now those expectations cannot be for you. And basically, you are under pressure from your own close ones. Outsiders, you don't have any pressure, but your close ones. How to handle that? That is why judicial aloofness, that's another word, judicial aloofness. What is that? I used to ask people how this system of giving security to the judges started. Well, because normally judges are never under attack. Suddenly, now the concept has changed. They used to say that initially it was given because they did not want everybody, litigants used to come and walk into the house of the judge, said, sir, this is my case, please. So to shield them, it was for aloofness. Now it has taken another shape. Now it is more of a social thing, your protection. We don't need if you're a judge. So this was the concept for why security for judges started. Because they had easy access, straight away walk to a house, just talk to the judge, sir, this is my case. Or you have met, sir, I met you there, sir, this is my case. Once you meet somebody, you smile, you get a photograph with him in a function. He says, no, I have a direct link. This is society. You can't help that. You can't even blame them. But then onus is on you. how you deal with it. It's a very difficult situation, and ethics itself encompasses everything. Nothing is left. Your judicial work, judicial acumen, everything. And I'll tell you, you don't have to feel inhibited that, oh, I don't have too much command on the law and all. Everything here, issues are decided at the bar. I keep telling people that if you don't hear, you are causing harm to yourself, because the person who's standing here has taken fee. It may be more than your month's salary. Why don't you make him work? You tell him, get me all decisions, get everything. Let him work if he has worked. Why do you keep quiet, and when you start writing a judgment, then you are lost? This precedent, nothing is there. And then you have a poor show in your judgment, because it is your, you are the author of that. But because you have not made the advocates, the counsel's work, you suffer. Now you do your original work, put things into that. For what? Let them do it. You are there only to see which is a more plausible explanation, what the law actually should be. But we say that no. Then you, and that is why you start having difficulty in writing a judgment. And if I told a judicial officer that yes, you can do everything, but you don't have to write a judgment, everyone will become an ideal judge. Your only trouble is, let me pass such a big judgment. Let me 3 years just pass away. If people told you, okay, you don't have to write a judgment, everybody would be recording all evidence and everything. I don't think we'll have to say anything to anybody. The fear is that if I complete this, I'll have to write a judgment. The psychosis is with the judgment. Why not get accustomed? And one of the best lectures you will get is from Sir how to write judgment. I've seen his PowerPoint. That I feel judicial officers.
How to tackle that? Or it should be taking this
Ideas to put, how to put, that is the difficulty. And probably an all academy. That I do not read it in the material, and sometimes I go off. So they said, you better go prepared. So I prepared, but I think I've said enough. There's no need to go through this prepared delivery. And then I'm also looking forward, like sir, to the interaction with you. Thank you so much. Jai Hind.
Thank you, Your Lordship, for your valued insights and cherished guidance on the navigation of ethical issues faced by the judiciary. I now invite the honored and esteemed participants to kindly present their views and/or questions, if any.
Yes, yes. As Justice Oak has just said, your chief will also be keeping his ears closed and is not looking who's speaking. So you don't have to introduce yourself. You don't have to take any names. Just shoot the question. But you've turned back.
Please speak up. I have also some questions on your behalf, which I will be putting.
But he'll not look behind. I stand corrected. Who wants to impress his Chief Justice? The first person will be remembered.
I have a question, sir. I have seen when I was practicing Supreme Court, in the miscellaneous day, even half a minute time is not granted to the lawyers while we argue the matter, and the matter was dismissed. And this is one of the major complaint against the Supreme Court judges. So what is your answer to that?
I'll make an attempt to give answer. See, two things we must keep it in mind. That many cases which come to Supreme Court, it's a third round, fourth round, or fifth round that we have to remember. Secondly, somebody who sits in the Supreme Court has experience of 17 years, 18 years, and the amount of work which the Supreme Court judge does at his home. Sometimes we read the matters in 360 degrees. And look at the flip side of it. Ultimately, there has to be closure to a case. So if you are very liberal in Supreme Court, we keep on giving long hearing to the lawyers, unnecessarily burdening the court with many matters. I mean, it's, we can't issue notice mechanically unless there is something really in the matter, some good point is there, something needs to be decided. But this is the system in which we'll have to work. Otherwise, please imagine what will happen. There's a judgment of the civil judge, judgment of the district judge, then judgment of the High Court judge, and then hearing takes place at admission stage for 1 hour, 2 hours, or even for half an hour. But this is a system in which we work. And I will say that at the risk of facing a lot of criticism, we have no option but to continue this system. Because in very few countries, we get this kind of matters. I'll tell you one more thing. I always state that example. I attended recently, last year, a workshop arranged by Gynecologists Association in Maharashtra. They conduct legal workshops. So there was one very eminent doctor who asked me a question. The question was, in the topmost court in USA, there are no areas. And you people are taking holidays. You people take long vacations. So I answered that question by saying that in the topmost court in the USA, judges deal with 300 cases per year. And in our court, every bench deals with 300 cases per week. So this is how it works. Apparently, yes, sometimes I was also a lawyer. I have seen what happens. I remember one case where a very eminent surgeon from Pune had a case before the Supreme Court. I had conducted that case in the High Court. I also felt that there was nothing. But he being a very senior doctor, he said, no, we'll go to the best possible lawyer. So best possible lawyer was engaged. The doctor insisted on attending the Supreme Court. I tried to persuade my level best not to attend, but he attended. I was also with him. So the moment matter was called out, we had perhaps the topmost lawyer engaged. I'll not name him. So the senior judge said, Mr. So-and-so, High Court has considered everything. The senior lawyer did not utter a word and SLP was dismissed. So doctor asked me, sir, what has happened? I said, sir, I told you, inevitable has happened. So this is how the system works. There's no option because there has to be a filter applied in topmost court.
Can I just supplement, Brother Panigrahi? I just said that when we used to come, second point, by the time you could get third, no opportunity. But now we are more liberal. And on a lighter side, recently the Supreme Court Bar Association took a resolution that at least 2 minutes should be given. So sometimes we just jokingly say, sir, your 2 minutes is far that. So you have taken time for your colleague also. But now we are a little bit more patient. We do let you elaborate the point. Otherwise, it was just what is your point? 1, 2, and then if needed to elaborate. But we've been more patient and what has rightly fallen from it. Brother Panigrahi, you were with me in the United States. We went to the Supreme Court. It will be a very good thing for you, everybody to know. We asked the person, I think they did 70 or 70 matters in 1 year Supreme Court. And when I wanted to ask questions, I said, he said, yes, my secretary would explain to you how we work. So I started asking, what do you do? She started, sir, I plan the weekends. Then I said, what further? Sir, I plan where he stays. Then what do you do? sir, then how many people would go to coordinate? After 7, 8, not even one thing about the judiciary or judicial. Only what they'll do with this and this. After that, we said, thank you very much. He is witness to that. So you know what we do and what we can, you know as judges. Mr. Venkat Raman also knows because his associated judges know what to maintain us, not to maintain our sanity, that is one, but to do our work because the time we spend in court is for the litigants. Actually, our work starts after that. So we should not feel inhibited about that. I think why do you feel inhibited? I speak openly, explain, tell the truth to the world. They don't know. Many intellectuals will sign in writing and all. I keep telling my mind in very social occasions also to even these media person, everybody. Why do we feel inhibited about what is genuinely in our favor? The ratio of disposal, nothing to do with us. You see the numbers, how many each civil judge is doing commendable job. Sometimes we feel ashamed at what type of work they are doing. Not even the Supreme Court we are able to record evidence, do everything, write order, how they are doing. We know the difficulty. Then why feeling inhibited about it?
And one more thing, actually, I'm not here to defend. I mean, litigants do have a point of view that why don't we get such a lengthy hearing in Supreme Court? Why this is happening? Litigant has right to ask that question. A lawyer has right to ask that question. The flip side to it. Someday, somebody should make a study of what we do on Mondays and Fridays. There are a number of cases where without lawyer even opening his mouth, we dictate an order granting interim relief. That also happens without giving hearing to the lawyers. So you are right. See, I'll tell you one more thing. I have openly said that our system is not ideal. I have said that because there are flaws in our judicial system. And this is one of the flaws, but we can't help it. Kind of matters, the number of matters which are filed in the Supreme Court. Basically, everybody will feel that, no, our court should be ideal, but we don't live in an ideal world. And that is how such flaws come into system.
Sir, I want to say one thing.
Please sit.
No, sir. The problem what we are saying this, the High Courts and the Supreme Court also is now flooded with bail applications. The 50% of the cases are bail. I think there should be a confidence built up amongst the district judiciaries that they should give bails and without being fear from the higher, I'll say the High Courts and the Supreme Courts. The second point is, sir, as a High Court and the Supreme Court, we should see one thing. We should not write in the judgments against the judicial officers. This is a moral which they face. They take a moral beating. If there is something, a person is bound to commit some mistake. If he is committing a mistake, tell them one-to-one as a guardian judge that this is the mistake you are committing. But getting that in the judicial orders, it gets a different, I'll say, impact on them.
Oh, I'll tell you, this. That's right. See, this is a harsh reality. Today, we get in the Supreme Court cases which are magistrate triable, charge sheet is filed, matter is not heard for a couple of years, and the litigant does not get bail in 3 courts. This is a very good question. Brother Bose is not here. He'll remember that on 19th of May, we had a conference in Bhopal. We had called all district judges in charge of all state judicial academies. Perhaps district in charge of this academy was also there. So I was informally discussing with many of them. And one of them showed courage to say that openly. He said that, sir, why judges are not granting bail? It's not that judicial academies are not making any effort. I have myself gone to many judicial academies, delivered lectures on what should be the approach in bail. The theories of transfer. Always a judge has in the back of mind fear of transfer. And perhaps we who man the high courts, I blame myself for that also, we are also to some extent responsible. Because fact of the matter is that we criticize the judges because judges grant bail. So we need to change our approach and we need to protect our judges. I think in your judicial academy, I gave example, I give it for benefit of others. It was a case of, at one particular district level, it was a case of murder of a very learned man in the society. The case resulted into acquittal. There was huge uproar on the social media, printed media, because the then Chief Minister had made a public promise that will ensure that offenders are hanged. That is what we experience every day. These ministers and political leaders, they give assurance on behalf of judiciary. Then there was a demand for transfer of that judge. The Chief Justice told me to go through the record. And I found that judgment was flawless. I think there were one or two eyewitnesses to the incident. Eyewitnesses never knew the accused. And it happened in fraction of seconds. Gap was about 7 years from the date of incident and recording of evidence. Test identification parade was not held. And perhaps in one of the witnesses was shown photograph of the accused just before recording of evidence. What that judge will do except to grant acquittal. So as judges of the High Court and Supreme Court, we have to take more pragmatic view of the matter. Because nobody should be blamed, no session judge should be blamed because he has granted acquittal or he has granted bail. So this fear in the mind of the judges, we have to work on that aspect. And unless we work on that aspect, we sitting in the constitutional courts will get more and more bail work. There's no option to that.
I'll just add to that. I went to Jharkhand only on this issue, and we had just delivered that until I was party to it. So I went there and we said, and probably my response was that things started improving there. I went to Bokaro and on this only, and how the High Court should cover their backs. That is the most important what has fallen from. That is the key. The moment the High Court acts as a protector, you see the difference because they are only bothered about the High Court. They'll also forget about social media, everything. Their whole focus is their career, and rightly so. We can't blame them. The way we behave in High Courts and the Supreme Courts, rightly so. So that is the key. If you cover them, then I was sitting with Sir, and he also very reacted. Some type of stricture was passed. All of that, and we've given that. We made it uttered.
I have a question, sir.
Yes, please.
In the beginning of your speech, sir, you told about your friend appear before you. You did not answer what had happened to that. Whether we should entertain the very close friend in the bar appearing before us. This is first question. Second is often the complaint about Supreme Court is corporate clients or VIP litigants when they come even in the interregnum stage. Court give much importance to those matter and it goes on and on in a non-miscellaneous days also. This quite often this is a complaint by the common clienteles. Why preference are being given to the corporate clienteles or a VIP even in the interregnum stage? These are the common complaints every day we face. How to deal with that?
I'll answer the second question first. I mean, you are right there. You are right. We need to change ourselves, and I say it openly sitting in the court. Perhaps the complaint against me is other way around.
No, we don't have any complaint.
And the loud laugh came from
Oh, you know, we have an experience of your court.
That I don't entertain senior lawyers. A lighter vein. In fact, I entered very late, and what our dear AG said, one of the most learned lawyers I have seen in the Supreme Court. I mean, so always, treat to hear him in tax matters. But he immediately said that, sir, today you'll have to hear me. But what you have said is absolutely right. I have said it in open court that this is what is happening in our system. It should not happen. Our priorities are going wrong. I have said it in Bombay High Court. And I have said it loudly, not only orally, but in writing also, that what kind of matters we are giving priority. In fact, in Bombay High Court, one of the orders I have said, very eminent lawyers came before me. They said that, sir, it's a very important commercial dispute. My answer to them was, since when you have associated commerce with a with a dispute? or litigation. There can't be commerce in litigation. Every litigation is same. And I said so. If at all priority is to be given, priority should be given to matrimonial matters and cases involving liberty of human being. And that criticism is justified. And I accept that. All that is left is to, at individual level, we should work on it. Commercial Courts Act came. What was the necessity of that Commercial Courts Act? Why in our country we should give priority to the commercial, so-called commercial litigation? It's a legislative policy. Therefore, I was instrumental in setting up the first dedicated commercial court in India in Bangalore. But someday we'll have to think about it. Now that what is the specified value is now brought down to 3 lakhs, I think. See, courts should not contribute for enhancing our ranking in World Bank or somewhere. We should not be doing that as courts. So therefore, you are right. Priority has to be given to litigation of common man. And there, we should come together and make that endeavor. And this is the complaint. As a chairperson of Legal Service Authority, I went to all jails. We had camps in tribal area where 1,000 people used to come. Their complaint was the same. So when you are going to hear our cases, that was the complaint. And that's the allegation which we face. And we must deal with that allegation squarely. Even Supreme Court, I do that. I don't give priority to such cases. First question. You know, of course, every colleague in the bar or your friend, you can't say that you will not take up his matters. You can't do that. Maybe now times have changed. I remember, I'll give you an example. I worked with a senior for 1.5 years. He was elevated. I'm talking about 1985. Now times have changed. I went to him just one day before his oath and asked him, sir, can I appear before you? His immediate response was, do you really feel that I'm going to favor you? If you feel that I'm going to favor you, don't appear. But you know, now times have changed. Times have changed. And see, ultimately, as I said, justice should not only be done, but it should be seen to be done. So therefore, now somebody is very close to you, your junior in your chamber, maybe your distant relative, you have to say that you will not take up their matters. Because, see, 30 years back, nobody attributed motives to the judges. Now, easily, to our every decision, motive is being attached. So times have changed, and it is our duty to ensure that it must appear to everybody that our system is pure. And therefore, now this decision has to be taken. Therefore, now so many judges, now so many colleagues I know of Bombay High Court, now they have a list of 10 lawyers, 15 lawyers. Their cases are not listed before those judges because we have to take that precaution. But ideally, you are right. Only because somebody is your friend in the bar, you can't say that, no, I will not take up his matters. And we have to take other precautions also. In Bombay High Court, I started that practice. I devised a practice that only Advocate General, the government pleader, and Office Bearer of Association will get direct entry into my chamber. I prohibited entry to any lawyer unless he writes on a slip of paper given to him by my secretary that this is the nature of the work. For that, I want to meet the judge. So you have to remain aloof. But still, now in the changed situation, we have to be very cautious. For example, I don't take up SLP against order of a judge who was my junior. I don't take up because, see, ultimately somebody who was part of my family, I'm not going to take up matters where the same judge has passed an order and I have to decide whether it's right or wrong. Maybe if I was a judge 20 years back, I would have taken up those matters. Today, I won't take up the matters because we have to maintain our image as we are very impartial.
Sarah.
Yes, please. I was about to say you should ask me questions because it's the other way around in the court.
No, it's more because younger judicial officers are here. I want to put one perspective for you
Yes, please.
for guidance. This is based on statistics. When fake invoices were raised and fake GST claims were made, the annual fake invoices averages between 10 to 12,000 crores. So in the last 6-7 years, it will be 70-80,000 crores. Now, the first few years, this is based on statistics, we arrested about 473 people across India, and we collected 23,000 crores. Why? Because in any fake transaction, you always put some panwala, some shopwala. The original man will never come into the picture. And that fellow's bank account will hardly have 1,000 rupees. But he will be having a GST registration and crores of turnover. Every second month, they will keep changing. The bank account will operate only for 2 months. But the question is this, sir. In economic crimes, unlike the other type of crimes which happens, unless you catch hold of somebody, the assurance of recovery is remote, especially if money transcends across the nation. With such matters coming up now before lower judiciary, what will be, because times have changed, what will be your advice to them? That's question number one. Finally, what comes to the appellate court is a different issue. 2-3 reviews have happened and you have to take a call. But lower judiciary and empirical data says we collected 23, it's not a small sum. We collected 23,000 crores. Money came into the coffers. This is one question. Now, the second question is, sir, will you be amenable to this perspective also? Because it's not a court I'm just persuading to consider. Sir, it's not that corporate matters or economic matters. There are priority matters which involve intrinsically, now we are connected to the global world, whether we want it or not. So there are matters, our judgments are being celebrated, being discussed across the world in conventions, international conventions. When we take a call, when the Supreme Court of India takes a call, that judgment is having a huge impact in international conventions. That's the image we carry. So in that architecture, what should be our priority in matters of some importance? Which may not involve liberty, which may not, but it has a huge impact in terms of investments. It has a huge impact in terms of our image in the global stature. These are all changing times. So from that perspective, what will be your advice to the institution? These are the two questions.
I'm glad you asked both the questions. Now, first question, my advice to judicial officers will be to remember that we don't detain people under trials in jail for the purpose of recovering money from them. AG, I want to tell you, cases after cases, we find cases come to us, maybe so-called economic offenses. It's an offense ultimately. How do you say that economic offense is different from offenses against human body? The test for bail should be the same unless there is specific law like UAPA or PMLA where there are stringent or NDPS Act. Today, there is a perception which goes on in these commercial offenses that, look, sir, I have to recover 100 crores from this man, therefore detain him in custody. That is not our jurisprudence. Our jurisprudence is well settled in which cases we are going to grant bail. There is one more important aspect which I want to say with great deal of emphasis. Cases after cases, we acquit people not by giving benefit of doubt, by saying that it's a case of no evidence. Maybe a person is charged with violation of laws or economic offense. What happens to his years which have gone in jail? Other day, one very young lawyer argued before me. After 9 years, we granted acquittal. It was a case of no evidence. The lawyer said, sir, someday judiciary will have to think about compensating a person. So the law of the land is we don't keep anybody in jail because we want to recover money from him. I'll give 4 examples. At one, we are short of time. 3 cases in Bombay High Court. One involved defalcation of money in a very large education institution. A bail application came to me. I rejected the bail application because investigation was going on. You know the law. Once you reject one bail application, second, third, fourth bail application will come to the same judge. After 3 years, second bail application came to me. It so happened that investigation was carried out by the police. There was a petition filed under Article 226 that investigation is completely flawed. Therefore, some court said, appoint a senior IPS officer to make further investigation. Further investigation revealed that it was a fraud of some crores. Money was siphoned from the accounts of the very big education institution. The investigation carried out by the higher police officer revealed that the persons who were arrested earlier, they were not the accused. Somebody else was the accused. I had to grant bail. This happened in very sensitive case of 302, where a very rich man in one of the districts in Maharashtra was murdered. Same thing. SIT was appointed. SIT found that those who were arrested were not the accused. I agree with your point of view that if there is an offense which affects the economy of our country, then obviously such cases must be taken up with some kind of priority depending upon how many cases, other cases are there in that court. But it can't be the approach that we adopt different yardsticks while granting bail, because it will be disastrous. Disastrous in the sense that, see, so many cases every day in Supreme Court and High Court it happens. That prosecutor gets a, sir, I am opposing because this man has defalcated. He has grabbed some 5 crores or 10 crores, but not a single recovery, single farthing could be recovered. These are not recovery proceedings. And that will have to be the approach. Look at the role played by the investigating agencies. I have openly said that there are flaws in judiciary. We commit mistakes. We are not up to the mark. Are the investigating agencies up to the mark? Kind of investigation they carry out. And only because they carry out such investigation, somebody should remain in jail. So that's the, so my answer to, my advice to the judicial officers is, don't get bogged down because somebody gets up and tells you, look, crores are involved. That may be only one of the relevant considerations for grant of bail. That can't be the sole consideration. Secondly, our constitution is 75 years old. When constitution came, every common man expected that he will get justice. Look at the cases we have. One matrimonial dispute now has 5 grassroots level cases. Then appeals, then revisions, then SLPs, transfer petitions. And they are on rise because that's a societal change, whatever. We are not social scientists. Every judge sitting here, he knows how many cases. And one matrimonial litigation creates 5 grassroots level cases. One petition for divorce, restitution of conjugal rights, DV Act, then custody petition. Now a new 498A, now a new kind of prosecution has come. Husband and wife exchange WhatsApp message. Therefore, under the IT Act, one prosecution. Now, one matrimonial dispute affects 3 families. One is that family of husband and wife. If they have children, that is worst. And the family of the wife and family of the husband. There are cases filed before the High Court. Somebody, after working for 25 years, doesn't get pension. Somebody doesn't get retirement benefits. In Maharashtra, we have grantee-aid schools. After following procedure, teachers are appointed. They start working. But since it's a grantee-aid school, some officer of education department has to approve that appointment. Unless the appointment is not approved, he won't get salary. In Aurangabad bench, hundreds of cases are filed. A teacher works because there is no approval, he doesn't get salary. What kind of education he may be imparting? These matrimonial cases affect the entire society. I can give you hundreds of examples. Go before our labor courts and industrial courts. People work for 18 years, 20 years at a salary of some 100 rupees per day. Our country is different from developed countries. our country, common man is crying for justice. And what are we achieving? Oh, we write very brilliant judgments in the commercial matters. We write brilliant judgments in arbitration matters. So that at international level, somebody should praise us. Nothing wrong with that. Mr. Venkatraman, nothing wrong with that. Our judiciary must carry that image. But do we exist only for the purpose of projecting our image? Our image will undergo change the day common man of this country feels that from this system, I am getting justice. And how do you get justice? In 2002, our Supreme Court ruled that just to population ratio in India should be 50 per million. Today, we are struggling at 19 or 20. In trial courts, I'm talking about trial courts. Now, go to any court in any metropolitan city. We have converted a civil wrong into an offense, 138 of Negotiable Instruments Act. Go to, now of course, metropolitan magistrates are no longer there. Go to the courts of magistrates. Go to Mumbai, go to Chennai, go to Bangalore. 50 cases, 100 cases under 138 of the Negotiable Instruments Act. They are on the board of the magistrates. 20 cases under the DV Act. 20 cases under 125. Are these judges supposed to give priority to so-called commercial matters? That's the question we'll have to answer. Should we be bothered about our image abroad, or should we really ask the question to ourselves? We have taken oath under the Constitution, all courts, including all civil courts, which we should not be calling as subordinate courts. They are equally important as constitutional courts. We are working under constitutions. We should be asking question to ourselves whether we should work for improving our image or whether we should work for ensuring that common man gets justice. So that is the approach which I have always advocated and I will continue to advocate. That's the approach.
The first right is that of the Indian citizen on its
Right.
this institution. That is his first right.
Now let us be very frank. Why that 1 crore specified value has brought down to 3 lakhs? So that we can show that we are disposing of large number of commercial cases. Is that not correct?
3 eminent judges of 3 high courts, 2 high courts, and additional advocate general, they have interacted. Can I request
Sir,
the
AG,
judicial-
sorry for being harsh, but these are my views which I have canvassed for last 21 years. Right, correct.
Can I
And
request the
perhaps in
judicial?
lighter vein, perhaps those who appear before me every day and day in and day out, they know these views.
So can I request the judicial officers to come up with questions? Some judicial officer.
Actually, this session
Yes,
is
yes.
meant for you all.
Please, please.
Yes.
Please, somebody wants to ask.
Lordships, I am often advised by my brother colleagues and some of seniors also that you must not be predictable. And the opinion I am having that a judge must be predictable, that if there are certain facts, that will be the decision, because the law states on these facts, this law applies, and this should be the decision. I want to know, Lordship, whether it is really to be a good or safe practice to be non-predictable.
Very shortly and briefly, I'll answer the question. I don't think we should be thinking whether we should be predictable. The real rule is whether we are consistent. So law has to be applied consistently to the same set of facts. So we have to be consistent. That's the only answer to your question.
May I add with the permission of my lord? You said that the people branded you as being predictable. If the predictability is based on very sound legal considerations, then let them label them to be predictive. The word actually is you should be consistent. And if your predictability is, in inverted comma, is based on sound judicial principle, then what is the matter? The main crux is that whether it is based, you don't give priority to something which is extraneous, just because this section is there, I'll not give, or this section is applied. So that is not predictable. That will be predictability and a negative predictability. But if you based on sound things, like many people have the concern, oh, if this section is there, that court will straight away say no. That should not be there.
No, perhaps I misunderstood your question. I think what you want to suggest is this. Where we face criticism, one set of facts, A appears, judge passes X order. Same set of facts, B appears, judge passes Z order. That should not happen. And there we have to be consistent. Because if we are consistent, that will send correct message.
The judge is likely to be exploited by the bar. That may be the main question. The exploitation by the bar. That may be the reason he's asking for it.
We will say that somebody, see, I tell you, I mean, right. See, Justice Loda said in one of the public functions that every day we are being sold in corridors of the court. He referred to perhaps Bombay, but I know what it happens in Bombay. See, we see every day, I mean, we are all human beings. So somebody will say that as far as this judge is concerned, he is very liberal in granting bail. Somebody will say that instead of arguing bail application before the judge, better to withdraw the bail application. But I don't think that anybody can take undue advantage of this, because if I am correctly deciding the cases, I am correctly following the principles laid down for grant of bail. How anybody can take undue advantage? Because I am following law. Wherever bail deserves to be granted, I will grant. Wherever it doesn't deserve to be granted, I will not grant. Now, there are always unscrupulous members of the bar who do mischief. That's what Justice Loda referred to. That he will give assurance to the litigant that, look, you will get a bail in this case. It happens because, co-accused granted bail. So we know how lawyers behave. Same set of facts, application is made on behalf of co-accused. These are the things happen. But what I personally feel is this. Maybe in one or two cases, somebody, some lawyer, some litigant may play mischief in your name. He may give assurances. But I still believe, after spending 21 years in this institution, that if you are straight, if you are bold, if you are fearless, such few aberrations by mischiefs by members of the bar don't affect your image at all. Your image remains intact. So we don't have to bother about this. See, if we are deciding correctly, why should we bother about one thought process that somebody will take undue advantage of my decision? Well, so long as you are deciding correctly, why should we bother about it? That should be our approach.
I think we have time for one more question.
One more question.
Can I ask a question?
Yes, please.
I have another important question. There are some matters, maybe in constitutional issues or maybe some commercial matters. We have a prolonged argument. Argument goes on for months together. So, in fact, the issue in the matter that could have been solved could have been heard in 1 week or maybe 10 days or maybe 3 days. But unnecessarily that is prolonged, and it is, as a result, the important matters in the court that gets neglected. So, what should be our approach to to curtail such prolonging of the matters of argument of such matter?
See, two things which I always tell the members of newly appointed judges. One thing I always believe that if in a given case which doesn't require arguments for 2 days, if some lawyer argues for 2 days, it is our failure. Because we have to control the members of the bar at the risk of being unpopular and at risk of being harsh. Ultimately, in our court, we have to tell the lawyers that, look, I am not going to grant you more than 1 hour. You have to finish within 1 hour. So when we say that, lawyers are taking me for ride, they are arguing for hours together, it is our weakness. We should not allow lawyers to do that. We should not allow them to hijack our system. I I remember other day in Supreme Court, once it happened to High Court also. So some lawyer said, sir, I will take whole day because high stakes are involved. So I corrected the lawyer. I said, what is the meaning of high stakes? Only if your case involves some few crores of rupees, or say 1,000 crores of rupees, it is not a high stake litigation. There may be a very complicated issue under labor law. There may be a very complicated issue. Now, for example, these 3 new laws. Suppose some issue comes up before us of this Bharatiya Nagrik Suraksha Sanhita. There are some provisions which will require a lot of debate, which will affect thousands of litigation across the state or across the country. According to me, we should not be using that phrase at all, high-stake litigation. But in practical terms, that will be a high-stake litigation. You should be devoting a lot of time to that because so many common people will be affected by your judgment. So ultimately, fault lies on us. And secondly, one more thing I'll tell you. Somewhere we are helpless. When I started my career as a lawyer, senior used to tell me, or for my own matters, find out case law. It was a very tedious process. We'll pull out so many commentaries, so many digests. Then we have to go to, because half of the commentaries, they used to mislead us. We used to feel that after reading commentary, this is a direct judgment. But when we used to take out the actual law report, it used to be something different. So research used to take a lot of time. And therefore, in those days, lawyers used to rely upon, say, 3 judgments, 4 judgments, 5 judgments, because all the books were physically required to be carried to the court. And now by one click, you get 20 judgments on a point. So today we have a scenario in our trial courts where there is for example, I'll give one instance. If there is a direct judgment of the Supreme Court on, say, discretion under Section 20 of the Specific Relief Act, what the lawyers would do is 3 judgments of the Supreme Court taking the same view, 5 judgments of the same High Court taking the same view, and 10 judgments of other High Courts taking the same view. Because it's very easy now to come. So, in fact, while I deliver lectures on this art of writing judgments, now I'm trying to evolve some formula whereby the judges need not refer to each and every judgment on the same point. But these are the flip side of technology. But I still believe that allowing lawyers to argue at length, especially in constitutional courts, our friends in trial courts and district court may have some difficulty. Sometimes entire bar association is very cantankerous. They will pass some resolution. But sitting in High Court, I think we should be able to control. And I always said in one of the workshops of the High Court judges that these are the areas where we as High Court judges, we should be meeting and evolving common methods. It should not be that some judge curtails the lawyer and other judge allows him to argue for hours together. So we need to make correction at our own end. The basic principle is that every single minute of every single second of the court time is very precious, and we should not allow anybody to hijack that time. That's the principle. Now we'll have to evolve. Otherwise, these lengthy arguments, the institution will get crushed under these lengthy arguments.
I'll just add to what Sir has said. Now we have started the practice. Mr. Venkatraman assisted me in 2 major matters. We are there. Right at the beginning, we mark a slot. We said half an hour, and we don't let them exceed that. Either you conclude or you leave your point. And secondly, what I'll tell you personally, which I've been insisting with all my learned counsels who assist me, that don't repeat. The tendency in lengthy argument that the same point is being repeated by the other side. So if you can control that, and then it is your court, whether you complete or do not complete. If half an hour slot is there, maybe 1 or 2 minutes, but it has to be. And I think in the Supreme Court, there is more of discipline in that way. If you fix a slot, then people fall in line. But you have to, it is your court, you have to take a stand, which will little bit difficult if the tradition has not been there.
And we'll close with one more thing. After I was elevated as judge of the Bombay High Court, I went to a very eminent retired judge of the Supreme Court, unfortunately no more. He was known to be very strong and very powerful judge. So I went to him. I sought his advice. He said, only one advice to remember, that don't ever make an attempt to become a popular judge. And he added a rider. He said, but also remember one thing, you need not do something which is wrong, by which he will become unpopular also. But the basic message he gave was, we are not in a popularity contest. We are here to discharge our duties as a judge.
One last question, because somebody from the.
Yes. One, somebody raising hands.
Very good afternoon to my lords. My lords, as one of my senior has asked a question whether a judge should be predictable or not, to which my lords has replied that it's not the matter of fact that he should be predictable or not. The issue is that he should be consistent. Now, suppose, my lord, what we face in our court in a routine basis, in a case where there are more than 5-6 accused, suppose 10 accused, in which in 4 to 5 on the they are behind the bars on the same set of facts. Out of 5 accused, the court has rejected the bail, and all the 5 accused has been granted bail by the higher courts. Now, whether a judge should be consistent on his view or he should be corrected by the observation made by the higher court and grant bail, and if no, then whether it should be called a justice, because anyways the other set of accused will anyways they are going to be released on bail, but it will take time for the another 5 to 6 months.
See, there is a very well long-standing principle of parity. Now, when parity will apply, if higher court grants bail to an accused, when the sessions court hears the bail application, if parity is applicable, you have to grant bail. You may be carrying different view, but you are bound by the view. Question is whether parity will apply.
My lord, it's for the another set of accused who are behind the bails.
But if parity applies, you have to grant bail to them. Parity is not applicable, you can take your own view.
My lord, then we are not consistent with our own view.
Sorry, just 1 second.
My lord.
There are 10 accused in one case. 5 are granted bail by the higher court.
Higher courts.
Correct. Now, when remaining 5 accused apply for bail before your court, there will be 2 contingencies. One, if parity is applicable, you have to grant bail. If parity is not applicable, then you have to follow well-settled principles and ascertain whether he is entitled to bail. It's so clear.
My lord, that means even if you have rejected the bails of the previous 5 accused, we can grant bail for the rest of the.
Why not? Why not?
My lord.
Because in case of those 5 accused, higher court has granted bail. Correct. And then other accused comes before you who is entitled to parity. You have to do it. In so many cases, it happens.
Now, my lord,
I'll tell you one example. In civil case in Bombay High Court, I took a particular view in testamentary matter. Particular view dealing with a probate application. Bombay, is full of probate applications. Now, my judgment was corrected by a division bench. It was upheld by the Supreme Court. So I had to take a view in subsequent matters which was contrary to my own view. Because I am bound by judicial discipline.
My lords.
See, we are always not correct.
My lords.
And just adding to that parity, suppose the Superior Court has held that going into the issue of the period of incarceration, suppose the other set has come later, then you can have a distinction that I have maintained because the time was very less. But if parity in every aspect is there, then you are bound by because that is now the law.
Lords.
So you can't, but parity itself is something to be judged by you. So that onus is on you. Otherwise, granting of bail on that matter, then your discretion goes for practical purposes.
My lords. Thank you, my lord.
And the 6th accused come to me. I see that the accused is entitled for bail. In the name of consistency, shall I reject the bail or shall I grant the bail? That's the problem. That is where the problem.
I think you have started on a wrong foot. You said the higher court has wrongly. How can you make a judgment on that?
Colleagues.
I'm not saying.
Colleagues.
I'm not saying High Court. I'm not saying High Court. Coordinate bench. I'm not on the High Court also. For a district judge, if he sees 5 accused has been wrongly rejected, the bail has been wrongly rejected, 6th accused comes to him. He sees that yes, he is entitled for bail. In the name of consistency, shall he reject that or he allow? That's the question.
See, if role is identical, role of the accused who come before is identical, perhaps you have no choice. because there has to be consistency. But one more thing, there are subsequent events. For example, your colleague has rejected the bail applications 2 years back, and identical case comes before you. You are entitled to take a different view on different ground. That for last 3 years, trial is pending, when charge is not framed. Or some court has stayed the trial. You can always say invoke Article 21 and say that normally I would not have granted bail, but this delay in conducting trial brings about a change in circumstances which requires different view to be taken. You can always use that. But otherwise, you have to be consistent. Yes, sister,
Possibly-
she has taken.
On the same,
We cannot say that the coordinate bench had wrongly rejected.
That we can't say. That's a constraint on us.
Even if, even if you cannot say that the coordinate bench had wrongly rejected the bail and a case of bail
Correct.
is made out,
Correct.
therefore you shall grant bail. This approach, you can distinguish this case on
No.
any ground.
We can grant bail
Subsequent
on the basis of change in circumstances.
Change in
No difficulty on that.
circumstances.
No difficulty on that.
But that is what we call judicial discipline. So that we need to maintain.
Judicial restraint and judicial discipline both.
and sir, in cases where suppose bail has been granted and the reasons are not supported by the materials on record, and that is brought to your notice, then what do? Maybe by mistake or because some negligence of the council or whatever.
No,
But-
but if parity is applicable, you can't take a different view.
But if the reasons are, the record shows that these reasons are not
So,
supported.
see, that is your perception. Your colleague on the basis of same material has taken a see, you have to look at the point of view of the person who appears before you. Why should a person feel that on same set of facts, the co-accused has been granted bail and I have been denied bail because there is change of judge. And even whether judicial discipline enables you to even think like that one accused has been granted bail, his order has been confirmed or not challenged. Judicial discipline may not permit you to go into the question whether your brother judge could have granted bail on the same set of facts. Your hands are, see, ultimately you have to follow judicial discipline.
Sir, I'm not talking about
No,
the reasoning. I'm talking about the
I
facts.
suppose
Facts.
Facts means some material is not brought to the notice.
Or the materials which are
Right.
mentioned and not there in the record or beyond the
May
record.
not be, but then remedy is available to the prosecution to apply under 439(2).
No.
But
I've gone through that on two occasions. A matter was brought before me. I rejected, and then it said that no, the coordinate bench has granted bail. I noticed all those facts. What I did, sir, is better now to advise on that. What I did in two matters which came to me when I was in Patna, I referred that these things are there. This has probably gone unnoticed. So I'm sending the matter back to that judge to take view because he has passed the order. Let him be consistent. But I just point out that this has been brought. This has not been noticed. I did it in two matters. And then you send it to the coordinate bench so that that judge is also aware that, look here, I missed these points.
Missed
Let him
it
take
was
a
not
call.
brought to his notice. Yes, that.
But I wrote down everything. I wrote down what was missing and according to me, which was relevant for this consideration, has not been brought up.
Question which, it was not the question, I was going to make 3-4 statements and that emerged with the question which was put by Anand Sen, that there are 4 statements, or 3 or 4. Judge has to be fearless. That is his virtue. And most of the judicial officers today join judicial service as a career, also for earning salary, livelihood, for maintaining the expectation that they shall be fearless in all times, particularly when they don't get that kind of protection. Rather, they feel scared of some scathing remark, some action by the higher courts. So my suggestion, now it has come during the discussions, that the constitutional courts should be very careful about our judicial officers, we should create an atmosphere that they should feel independent about the decisions which they take. They should think that they discharge the same function which the topmost court discharges, like when it comes to decision making. So this confidence should be enthused. This confidence should be given to them. This is our obligation of the constitutional courts. This is what I was going to suggest, and in fact, this is what I was going to converse on behalf of the judicial officers.
You are right. Actually, when we write judgments, we should not contain name of the judge who has passed impugned order. And especially when we say something adverse in the sense that there is non-application of mind, etc. We have to be very careful in that. Because, every judge is a human being. On a given day, I always compare this with a game of cricket. Even Sunil Gavaskar can be a worse form on a particular day. So we commit mistakes. So they are all aberrations. I mean, something happens in the family in the morning, you decide a case wrongly. But we should be very, very slow in attributing motives or saying that in non-application of mind, and especially naming the judges.
Some margin for the human element. I'm not taking names, but Such Anita is aware of taking names.
In fact, I make it a point. I even don't say designation of a judge, that additional session judge, so and so. I say only session judge. Even you mention that the designation, somebody can find out who is that judge.
With this, we have come to the end of the interactive part of the session. I thank the honored dignitaries and the esteemed participants for their kind participation in this interaction. Before we wind up this session, we would like to take this opportunity to felicitate Honorable Shri Justice Abhay Srinivas Ok, Judge, Supreme Court of India, as a mark of our immense regard and humble gratitude. For this, I humbly request Honorable Shri Justice Chakradhari Sharan Singh, Chief Justice, High Court of Orissa, and Patron-in-Chief, Odisha Judicial Academy, to kindly adorn the Uttariya and present the memento to His Lordship.
Traditional. Oh, this also traditional.
Thank you, Your Lordships. We have now come to the end of this session. We now take a break for lunch. And after the lunch break, we request all the honored dignitaries and esteemed participants to kindly reconvene here before 2:45 p.m. for the commencement of the next session. Thank you. The court's authority depends on the public's trust on its judgments. So judicial judgments must take deep account of the day before yesterday to ensure that yesterday does not paralyze today. Namaskar and a warm welcome back to the third session of this East Zone 1 Regional Conference on Contemporary Judicial Developments and Strengthening Justice Through Law and Technology. This session is on judgment writing tools with focus on language and law, brevity in drafting, fundamental principles of judgment writing, legal analysis to sentence structuring and editing, transparency and public confidence through lucid judgments, sensitivity in judgments, gender sensitivity in judgments and orders, and eliminating bias, stereotypes, and prejudices. To begin with the session, I now humbly request Honorable Shri Justice Prashant Kumar Mishra, Judge, Supreme Court of India, to kindly adorn the dais, and I request Shri Prabhakar Gantia, the esteemed Member Secretary, State Court Management System, High Court of Orissa, to kindly conduct his lordship to the dais. Thank you, Your Lordship. I now humbly request Honorable Shri Justice Chakradhari Sharan Singh, Chief Justice, High Court of Orissa, and Patron-in-Chief, Odisha Judicial Academy, to kindly adorn the dais, and I request Shri Vidyut Kumar Mishra, the Director, Odisha Judicial Academy, to kindly conduct his lordship to the dais. Thank you, Your Lordship. I now humbly request Honorable Madam Justice Anuva Rawat Chaudhary, Judge, High Court of Jharkhand, to kindly adorn the dais, and I request Shri Santosh Kumar Dashray, the esteemed Officer on Special Duty Vigilance, High Court of Orissa, to kindly conduct her ladyship to the dais. Planting a tree is a continuous charity, for the true meaning of life is to plant trees under whose shade you do not expect to sit in. To do the honors, I request Judicial Officer Shri Lalitindu Debata to kindly present Honorable Shri Justice Prashant Kumar Mishra, Judge, Supreme Court of India, with a sapling. Thank you. I now request Judicial Officer Ms. Smita Lakra to kindly present Honorable Madam Justice Anuva Rawat Chaudhary, Judge, High Court of Jharkhand, with a sapling. Beginning with the speakers for this session, may I now humbly request Honorable Shri Justice Prashant Kumar Mishra, Judge, Supreme Court of India, to kindly address the gathering in this session.
Honorable the Chief Justice of High Court of Orissa, Sri Chakradhari Charan Singh Ji, Justice Anubha Chaudhary, Judge High Court of Jharkhand, my brother and sister judges from High Court of Orissa, Jharkhand, Bihar, and the last but not the least, Chhattisgarh. My dear judicial officers from all the 4 participating states, the Registrar General, Director Judicial Academy, and other officers of the registry and other judicial officers from Orissa. A very warm good afternoon to all of you. As we say, post-lunch session is always difficult for both the speakers and the audience as well. But I hope I will try to keep you engrossed and absorbed so that you keep on hearing and while writing judgments also. This topic for the present session is about judgment writing tools. And to cover the topic, it is bifurcated in 4 sections dealing with language and law brevity in drafting, transparency and public confidence through lucid judgments, fundamental principles of judgment writing, legal analysis to sentence structure and editing, sensitivity in judgments, gender sensitivity, and eliminating bias, stereotypes, and prejudices. In the midst of swelling litigation, backlog, and insufficient research facilities, writing a good quality judgment is an ongoing challenge. Though of late the research facilities have improved. Justice Oliver Wendell Holmes told, "The life of the law has not been logic. It has been experience." A judge renders justice through his decisions. The decision-making culminating in the judgment is the heart and soul of the judicial process. Good judgments enhance the prestige of the judge and eventually the prestige of the judiciary. Brevity in the drafting of judgment is a crucial aspect that ensures clarity, precision, and efficiency in judicial communication. However, the challenge lies in balancing the need to convey complex legal reasoning with the necessity of maintaining an accessible and concise narrative. Legal writing is not just a task, rather, it is an art that every adjudicating officer or judge must imbibe as an important skill. A judgment may be defined as a reasoned pronouncement by a judge on a disputed legal question which has been argued before him. It is a literary composition, but a composition subject to certain conventions. It possesses its own characteristics and its own standard of merit. This art of writing judgment is not taught. It is acquired by practice and by study of the models provided in the innumerable volumes of law reports in which are recorded the achievement of past masters of the art. There in fact have been many books which have highlighted the significance of brevity in legal writing. One such book titled Legal Writings, Sense and Nonsense authored by David McClintock, a lawyer and professor, emphasizes that verbosity can obscure meaning and lead to misinterpretation. This becomes even more difficult when English is not your first language, like here in India. Therefore, Indian courts have time and again emphasized on the need to make judgments more accessible and free from legal jargon, to make them comprehensive and readable for the litigants and common citizens of our country. This further allows for a transparent access to the reasoning behind the judgment, which is necessary to build trust and confidence in the judicial institutions. It must be remembered that language barriers can cause overt discrimination, which finds no place in our legal justice system. Precision and clarity should be prioritized over language that sounds poetic or is inaccessible. Clarity requires us to not only focus on what is being said, but how it is being said. A clear piece of writing delivers the same information without loss of meaning to the different levels of readers. In the 1964 Harvard Law Review essay on the language of the law by a famous poet, writer, and lawyer, Archibald Maclise, he said, lawyers would be better off if they stopped thinking of the language of the law as a different language and realize that the art of writing for legal purposes is in no way distinguishable from the art of writing for any other purpose. A simple understanding of this quote would mean that a well-written judgment would be clear and follow the same rules of ordinary English till the time a technical term or specifically a legal term needs to be used. The judgment must be designed and structured so that readers find their way through it easily and quickly. Judgment is an important document for the parties as well as the judge, but it is more important for the judge as it gives the reason for arriving at a conclusion. One must remember that a judgment is not written merely for the benefit of the parties. Rather, it is also written for the benefit of appellate court, members of the legal profession, other judges, students of law, and the civil society at large. Clear thinking can be the key to clear writing. A clearly expressed judgment demonstrates good legal reasoning. We Indians, being verbose, have flair while writing. We need to be reminded that more can be said in fewer words. Readability techniques can further improve the clarity of judicial opinions, thereby supporting the movement towards a more succinct and effective legal writing style. Understanding the complex needs of the Indian society with around 22 scheduled languages, reliance on English alone as means of communication has often caused a barrier of understanding. Therefore, to overcome this issue, the Supreme Court of India took an important initiative by means of introducing a promising software named SUVAS, Supreme Court Vidhik Anuvad software, through which the judgments which are primarily in English are now translated into various regional languages available free of cost on the eSCR portal. This one initiative today allows a broader section of the population to access legal information and understand the implications of this important decision without having to rely on lawyers. There have been several judgments by the Supreme Court which has highlighted the fundamental principles of judgment writing. However, there is no uniform style of judgment writing, and it is an ever-evolving and organic process. In State Bank of India versus Ajay Kumar Sood, the Supreme Court has observed that judgments are intended to convey the reasoning and process of thought that leads to the final conclusion of the adjudicating forum. The purpose of writing a judgment is to communicate the basis of the decision not only to the members of the bar who appear in the case and to others to whom it serves as a precedent, but above all, to provide guidance to citizens who approach courts for pursuing their remedies under the law. Such orders of the High Court, as in the present case, this is the observation by Supreme Court, such orders of the High Court, as in the present case, do a disservice to the cause of ensuring accessible and understandable justice to citizens. Every judgment contains 4 basic elements. Number 1, statement of material facts. 2, the legal issues or the questions involved. Number 3, the deliberations to reach a decision. And number 4, the ratio or the conclusive decision. A judgment should be coherent, systematic, and logically organized. It should enable to the reader to trace the facts to a logical conclusion on the basis of legal principles. It is pertinent to examine the important elements in a judgment in order to fully understand the art of reading a judgment. In the path of law, Holmes J. has stressed the insentient factors that persuade a judge. A judgment has to formulate finding of fact. It has to decide what the relevant principles of law are, and it has to apply those principles to the facts. The important elements of a judgment are caption, case number and citation, the facts, issues, summary of arguments by both the parties, application of law, and the verdict. Using plain English minimizes the risk of misinterpretation. Ambiguities that are created by the use of legal jargon and language can create confusion, potentially undermining the fairness of proceedings and leading to an increase in the number of appeals. Judgments that should be well articulated and presented in straightforward language, reducing the likelihood of errors rising from misinterpretation, allowing swift resolutions, and reducing the burden of the courts. Parties are less likely to contest a matter which is clear and transparent. We could even reduce the paper waste generated by courts if the judgments are kept concise, crisp, and clear. The complexity of legal language has posed a barrier of understanding the judgment. Again, I would emphasize that by adopting plain language in the legal document, the judiciary can enhance accessibility and comprehension, advancing a more equitable legal process. This is not merely a stylistic improvement, but a foundational change, ensuring that all individuals can access and understand the law equally, be it a party to the suit or a third party. When judgments are written clearly, they serve as a resource that can inform the general public about their rights, legal precedents, and the working of the judicial system. It creates public trust and engagement of the common man in the justice system, demystifying the concepts of law for non-experts and promoting a more equitable legal landscape. The techniques can be use of clear and simple language, short sentences with clear structure. Sentences should not be more than 20 words, avoiding long sentences, making them concise and clear. The focus must be on a single idea in one sentence. Sentences can be broken down into multiple sentences to preserve clarity. For structuring a judgment, the essential components are introduction of facts, issues, arguments, analysis, decision, and orders. Structuring by uses of headings, subheading, index can also be resorted to. And information must be laid down in a chronological order for the benefit of the reader. Focus on key points, prioritize important information. The key points must be highlighted and should not be riddled with unnecessary details. any information that does not contribute to the understanding of the judgment must be excluded from the judgment. Similar technologies or consistent technologies must be used throughout the length of the text to avoid complications. Avoid using synonymous words which might confuse the reader. Complex legal terms and legal doctrines must be put down in easier language or explained with examples. Glossary of terms which may be ambiguous and are necessary for legal accuracy, but may be unfamiliar to a common person. We now come to the sensitivity part. Sensitivity in the judgments are now in this age of the media and information technology, the society itself being sensitive, the landscape of the legal system is undergoing a transformative shift, recognizing the imperative need to address and rectify historical insensitivity towards survivors of sexual offenses. Two landmark cases, Aparna Bhatt versus State of MP and Patan Jamal Wali versus State of Andhra Pradesh, have highlighted the critical necessity for gender sensitization training, particularly for newly inducted judges. These cases have had a profound impact on shaping a more empathetic and survivor-centric language in the judgments. In Aparna Bhatt, decided in 2021, it has been a catalyst for change in the judicial approach towards gender sensitization. The Supreme Court's directives in this case underlines the importance of avoiding language and reasoning that trivialize survivors. The avoidance of victim-blaming language establishes a trauma-informed justice system with sensitivity-worded judgments, signaling the need for comprehensiveness to train judges to write for gender-sensitive judgments. The landscape of the legal system is undergoing a transformative shift, recognizing the imperative need to address and rectify historical insensitivity towards survivors of sexual offenses. Patan Jamal Wali highlights sensitivity in handling cases with multiple societal and cross-cutting identities. The Supreme Court addressed judicial attitudes and language used in courts and judgments towards the victim. This decision reinforces the necessity of understanding the societal barriers survivors face, advocating for an intersectional approach that goes beyond legal considerations. While writing judgments, the role of judicial officers is not only confined to interpreting laws and delivering sensitivity-worded judgments, but extends to encouraging an environment of fairness, empathy, and inclusivity within the judicial system. It is equally important to remember that being a fairly patriarchal society, our mindset have accepted several stereotypes as normal, which oftentimes gets reflected in the judgments as well. Therefore, in a step towards gender justice, a handbook on combating gender stereotypes was released on 16th August 2023, containing a glossary of gender unjust terms while suggesting alternative words or phrases which may be used while drafting pleadings as well as orders and judgments. It is a far-reaching document that offers indispensable guidance on steering clear of harmful gender stereotypes, particularly those prejudicial to women in a process of decision-making. For example, the alternative language suggested in the text handbook for housewife is homemaker, for unchaste woman, a simple woman, And this initiative is particularly crucial in the judiciary, where a nuanced understanding of gender issues is imperative for upholding justice and combating discrimination within the legal framework. Now, judgments have been defined in Code of Civil Procedure, CRPC, and elsewhere. And there is always debates goes on about what a judgment and order, what is the difference between judgments and orders. But the heart and soul of a judgment is precise mentioning of facts and the reasoning. Nowadays, it has come in vogue that we divide judgments into different sections so that it gives the reader the benefit of understanding the judgment. Like the case of the plaintiff, case of the defendant, likewise appellant on respondent. The legal issues involved. Or sometimes we only prepare the legal questions involved, like in writ petitions, where the courts are not required to frame issues. We focus on the core legal issue involved in the decision making. And it is not only for the reader or the litigant or the lawyers. My experience is that it is more beneficial for the judge also to understand the particular case and reach to the correct conclusion. Because most of the time we find that a judgment which runs into, say, several pages. In the midst of the dictation, we lose track of the real issue involved in the matter and tend to decide those issues which are less important than the one which are more important and should be given more time for decision making. And this is the stage, you see, where you as a judge, as an adjudicator, you falter. And your judgment, which is not focusing on the real issue, but focusing more on some trivial issue, is amenable for correction by the higher courts more than the one which is precise. You see, when the judgments are written in more details, running into pages which are not required, that reflects the confusion in the mind of the judge. The lack of clarity is lack of clarity not in the case, but in the mind of the judge. And when the mind of the judge is not clear, it reflects in confusion in the judgment. And when the judgment is confused, it is bound to be set aside. Unless the judge of the higher court is also confused. But you see, when we say judgment is an art, writing judgment is also an art. And any product of an art requires passion and zeal and commitment. Like a painter, when he starts painting, unless he is free of all other extraneous things in his mind, he will not paint a good painting. Like a poet he cannot write a good poetry unless he sits either after 11, 12 in the night looking at the stars and writing his poems, or in the morning. I am not saying that you look in the stars and write judgment, because you have to read the files for judgment, not the stars. But what I am trying to convey is that you have to be focused in whatever you are doing. when your thoughts are erratic, it is not rhythmic, you cannot write a good judgment. And I'm telling you, you will always find that the case which you have attentively heard and prepared while sitting at home, while going through all the pages, you will find that you are really satisfied with your own judgment. I can tell you, if you pick up 50 or hundreds of your judgment and you read it again after some times, you will always find that I could have written a better judgment than the one which I have written. And this process of self-learning and realizing that where, at which part of the judgment I have committed mistake, that will enhance and improve your process of judgment writing. And there is no harm in learning from yourself. Learning from others at the later age, when you become a High Court judge or you become senior in the district judiciary, learning from others is a very difficult process. Peer learning is at the entry level, not at the later level. At the later level, later stage of life, you are your own teacher. And unless you focus yourself and consider as to whether my previous judgments are good or my present judgments are good, then you compare yourself and you will start writing better judgments. We always say, when we, as a lawyer and as a judge, we used to say that Justice Vivian Bose, his judgments are classic. Then Justice G.P. Singh's judgments, very precise, very compact. Some of us, or many of us, we are impressed by the language which Justice V.R. Krishna here uses. But in the present day, if you start using that language which Justice Krishna here used to write, probably the reader has no time to read that much of literature. And believe me, the litigants and the lawyers also, they are not interested in literature. A litigant always reads the litigant who has won the case, he reads the last paragraph. And the one who has lost will read the entire judgment. And why I say that a good judgment serves the principles of natural justice is that if you write a good judgment, the losing party, the party who has to appeal against, if he reads the entire judgment and if he is satisfied that since there is an appellate forum, I have to go, but the judgment seems to be correct. That is the victory of not only the opposite side who is not going to appeal, but the judge himself. When the losing party thinks that this is probably the correct decision, then that is the victory of the judge and the system itself, for which we are made for when we are serving. So we have to focus on writing good judgments. The thought process as a judge, we have felt it, and most of the time, we first decide whether I am going to allow or going to dismiss, and then supply reasons in the judgment about my opinion. There can be a debate whether this process of deciding first and supplying reasoning later is the correct process, or think of the reasoning why I should allow or why I should reject and then write a judgment is the better one is a debatable issue. But most of us, we decide first and supply reason later. And we search for better reasons, not because the law requires, but because I have to support my judgment and what I'm thinking about a particular case. That is the stage where we say, in Hindi we say, हम अपने अहंकार की तृष्णा करते हैं, satisfy करते हैं. It is my judgment and it has to be good. But the judgment is not mine, not Mr. Singh's, not Ms. Chaudhry's. The judgment is of the court, of the judge, and of the system. So we have to be very, very fair while writing judgments, and we must be open. Despite deciding first and writing, supplying judgments later, even till the last paragraph of the judgment, when you have to decide one way or the other, the real verdict, one should be open while writing judgments. Because nowadays there are so many, the judgments are based on case laws. The judgments, the trial court judgments are based on High Court's orders. And the High Court's orders are based on Supreme Court orders. And earlier we used to rely on journals, which are monthly, but today it is minute by minute. Every 15 minutes you will receive a notification from either live law or Benedictum or bar and bench, and immediately will feel that whether yesterday I was correct and today I am correct. So therefore, if you have the basics, there is clarity in your thought process about the legal principles, which you have not only learned, but experienced. And more particularly, the confidence in yourself while writing that this is the principle which should be decided in this case. There will be judgments. Judgments will come in, every day it will come, Supreme Court judgments. But the focus should be the facts of that case. It is not that judgment should be applied mechanically. The precedents should be applied mechanically for writing a judgment. And the judgment should not be burdened with many Supreme Court precedents or High Court precedents. They should one or two or three for a particular issue or principle is good enough. If you rely more and more on several Supreme Court judgments, that is again lack of confidence in your own thought process. To write good judgments, judgment writing tools are ever evolving, and as a judge, you are more competent to evolve your own tools for judgment writing rather than anybody else telling you. Thank you so much for this Orissa Judicial Academy and National Judicial Academy. Justice Bose is here, and we have all so much of respect, so much of learning from Justice Anirudh Bose. Under his aegis, under his leadership, NJ is excelling. And thank you, Bose Saab, for giving me this opportunity. Yes, no. Please, thank you.
Thank you, Your Lordship, for your esteemed and valued guidance on the art of writing judgments and for highlighting the importance of reasoned, transparent, and comprehensive judgments. May I now humbly request Honorable Madam Justice Anubha Rawat Chaudhary, Judge, High Court of Jharkhand, to kindly address the gathering in this session. Madam.
Flowing down. It's going to fall down.
You just need to.
This is next.
All right. Thank you, Madam Sukanya. Namaskar and a very good afternoon to all of you. Honorable Mr. Justice Prashant Kumar Mishra, Honorable Judge Supreme Court of India, Honorable Mr. Justice Chakradhari Sharan Singh, Chief Justice High Court of Orissa, Honorable Mr. Justice Bose, former Judge Supreme Court of India, and the Director, National Judicial Academy, all the judges who are sitting here from the High Courts and also from the District Judiciary. First and foremost, I would like to thank Honorable Justice Bose to have given me an opportunity to address you all. And as I see, you all are much more experienced than what experience I carry. But still, I will try to address the topic. And I must also say that Honorable Mr. Justice Mishra has almost completed everything. He has not left any corner of the topic left. Now, as he said that the judgment is primarily for the common man. So let us see, how does a common man define a judgment? And what is the purpose of writing a judgment? Judgment is essentially a determination of rights and obligations of parties, or finding the guilt or innocence of an accused, with a rider that everything has to be done within the four corners of law. Judgments directly deal with life and property of people, and not only with the parties, but also their family members and their extended families also. There are judgments which impact almost every citizen of our country and also across borders. Some of them determine the trajectory of the policy making of our country and even the future of our country. For example, the judgment on Aadhaar or the judgment on third gender. So judgments have wide-ranging impact. Let us see that what is the purpose of writing a judgment. Primarily, it is to inform the decision to the stakeholders with its reasons. The judgments are required primarily for the parties to the case, those who have to comply with the order to implement it, the members of bar and the public who may rely on it as a precedent, the appellate and the revisional court who has to determine its legality and validity, policymakers, legislature who have to formulate law depending on the judicial pronouncements. Judgments are also important for people and government from different countries who engage with our country and people in various strategic, economic, and social activities. Our judiciary is watched very closely by them, and our judgments are cited across the country. Primarily, a judge is a service provider to the litigants and to the society at large. A judgment is primarily for the use and understanding of the parties to the litigation. It is the litigant who is at the center stage of the judgment. The immediate consumer of a judgment in most of the cases is common man. Judgment writing for common man should have the capacity to communicate. The whole purpose of the judgment is to communicate with the common man. Simple judgment, when understood by masses, empower them to understand their rights, obligations, and duties, which by itself is a step towards achieving constitutional goals. It is in this context the language assumes importance. Simple language is a need of the hour. The judgments are required to be translated into local languages. Complicated sentences are bound to create more complications and errors. Beauty of the judgment lies in its simplicity, brevity, and clarity. Still, it should be complete in all respects. The greatest of all this is clarity, a virtue which comes only and only through clarity in mind. As a judge clears the clouds of doubts, the judicial wisdom rises like sunshine, clear and bright. Once the judgment is delivered, there is no scope for the judge to give any explanation or any clarification. Judgment is the only way through which the judges are expected to speak. There should be no gray areas in judgments, leaving it open to conflicting interpretation. Judgment is required to be expressed in a language so that it communicates exactly what is required and intended to be communicated. For this, we need a vocabulary which is good enough to communicate with the litigants. There is no need to have high-flown English language, which requires a dictionary to understand. Some of the common tools for clarity in judgments are: each sentence should communicate only one and only one meaning. This can be achieved by short sentences. Simplicity comes not only by simple language, but also by appropriate style of writing. Submissions of the parties and findings of the court should not be mixed up. Common man is not able to differentiate between submissions and findings of the court. Facts, submissions, and findings are required to be distinct. Nowadays, we have judgments divided into different headings. People have neither the time nor the patience to read lengthy judgments. In cases where lengthy judgments are unavoidable, it is always advisable to write a summary of the findings and directions at the end of it. The directions, if any, are required to be very clearly mentioned. For example, we have certain orders where the respondents is directed to comply the direction without indicating as to which respondent has to comply with the direction. So that clarity should also be there in the judgment as to who is the respondent who has to comply with the direction. Effective language is the foundation of a good judgment. The language by itself is the most powerful tool used in judgment to communicate completely, effectively, to have the desired impact and result. Writing judgment in simple language is itself an art, and writing judgment in common man's language is certainly a highly skilled art, which is required to be crafted and acquired through the journey as a judge. In fact, writing simple judgment is a reflection of the wisdom which is acquired through experience and knowledge of law. Presentation of judgment is also equally important. A judge must also ideally devote a reasonable amount of time to ensure that his judgments are appropriately formatted and do not suffer from any grammatical or typographical error. The pages and paragraphs are duly numbered to have quick references while discussing. The judgment should reflect continuity in flow of thoughts placed in a sequence. The style of writing varies from judge to judge. There is no prescribed format. Therefore, we need to focus on the essential ingredients of a good judgment. Different judges have different approaches in writing judgments. Some may start the judgment by framing the core issue. Others may start by the relief, and yet another may start with the cause of action. Some may record the short facts of the respective parties in their findings. Others may record the same in their arguments. Whatever be the style of judgment writing, there are certain ingredients which are common to most of the judgments: complete party position, relief, cause of action, short facts of respective parties, issues framed, short description of oral and documentary evidences, short synopsis of arguments, findings of the court supported by reasons, relief granted or denied. Each component has a crucial role to play. The simplest way of writing a judgment is that one can refer briefly to the pleadings, followed by submissions, set out the issues or points for consideration and take them up one by referring to the pleadings and evidences, followed by findings and directions. This traditional method of writing judgment is time-tested and has least possibility of missing out on any point or omitting to give clear findings on all issues. The party position is important, as no relief can be granted against a person who is not a party to the proceedings. The name of all the parties should be clearly mentioned. We have also seen certain judgments where it is mentioned Mr. X and others versus Mr. Y and others. We do not know who are the parties in that proceedings. In subsequent litigation, we waste so much of time to find out as to whether one or the other person was a party to the earlier litigation. Giving a brief description of relief prayed is important. Generally, no relief can be granted beyond the prayers. Cause of action is also required to be mentioned, which assumes importance primarily for limitation and jurisdiction. Facts are to be correctly recorded. Error on material fact makes the judgment perverse. Arguments are to be recorded. Evidences are to be considered, and the relevant provisions of law and judicial pronouncements which the party rely upon is to be considered. One thing on the first session we were discussing that at times our advocates are citing numerous judgments. They are citing on one point. So at the time of hearing the matter, we can ask the advocate as to on which point and which paragraph of the judgment he is relying upon. And then we can immediately ask him as to for one point, you choose your one best judgment. There is no need to repeat. So during the court proceedings, we have seen that they confine themselves to one or two judgments instead of citing number of judgments. And then we can record that these are the judgments that he's citing on a particular point. But this clarification has to be taken care of at the time of hearing of the parties only. Then comes the work of deciding the issues in the light of the arguments, the materials on record, the judicial pronouncements, procedural and substantive law followed by grant or refusal of relief. And then we have the final product, that is a reasoned judgment. Here we are on the heart of the judgment writing, the reasons. The requirement of reasons. Reasoned judgment can never be overemphasized. The main purpose is to inform the parties about the reasons for accepting or rejecting their arguments, particularly to the losing party, demonstrate that decisions have been taken fairly and correctly in the light of the applicable laws, and that the judgment does not suffer from any arbitrariness and bias. It also exposes a defect in the law or administration of justice, which can be taken care of. We shall now discuss a few examples of unreasoned judgment. We come across judgments where conclusions are correct, but reasons to arrive at that conclusion is missing. And the task of giving such reasons is practically left to the appellate court. While dealing with an order in a writ petition with dismissal by only one word dismissed, it has been observed by the Honorable Supreme Court that for the litigation, the duty of the judge is to uphold his own integrity and let the losing party know why he lost the case. It has been observed that the disposal of case is no doubt important, but the quality of the judgment is equally important. There are different types of lengthy judgments, but without reasons. Some extract the pleadings extensively and then refer to the arguments of the counsels of both the parties in extensive, almost till the end of the judgment, and ultimate conclusion is followed soon thereafter without adequate reasons. This is ex facie and unreasoned judgment. Yet another form consists of long extracts from judgments, one after another in unending succession. After long pages of quotations towards the end, the result suddenly appears. There is no connecting link between the extracts of the judgments and the result. Nowadays, even a bail application, even a bail order is required to be supported by reasons. Howsoever brief it may be just one line, but that is required. In the first half, we were discussing about the bail orders being not followed by the other benches, or maybe it's to what extent it is binding. If in a bail order, the reason is there, maybe one line, then the judge, it will be possible for the subsequent judge to give any distinguishing feature. And then whatever transpired in the mind of the earlier judge would reflect from the order itself. The giving reasons promotes public confidence in adjudication process and displays consistency in approach. There should be a visible link between the facts and the findings and the conclusions in the final judgment. Findings are to be arrived, conclusions are to be drawn, and directions are to be issued within the corners prescribed by law. Of course, we are entitled to define, redefine, fine-tune the law by applying acquired knowledge and judicial wisdom to the facts of a case. However, any major deviation which is in conflict with law calls for interference by higher courts. It is extremely important for us to know the boundaries, or which may call the Lakshman Rekha, within which we have to exercise our powers. Every adjudication in our country has to pass the litmus test of upholding the rule of law and demonstrate that it has been passed as per procedure established by law, and this should reflect from the judgment itself. A few words on open court dictations. We shall now refer to yet another common problem with judgments or orders dictated orally in court. The question is about the extent to which the draft can be corrected, modified, or added. This is a ticklish question. When we dictate the material, it is typed and it comes back. And in my opinion, the judge has a freedom to break longer sentences into smaller ones, or use active voice to make it more clear. And if the judge imposes some conditions, it can be put in a numerical order. An extra reason or a citation of the Supreme Court or a High Court at the end of the sentences can be given in support of the reasons. Modifications may be made to remove vagueness and to provide greater clarity. However, there should be no modification in submissions of respective parties and the final result, nor there should be any change in the fundamental basis upon which it has been decided. Delay in judgments is another matter of concern which invites public criticism. There may be good reasons for some delay, like the stenographer the judge has to comprehend, give dictation, the stenographer also takes some time and give. But there are numerous judgments of the Honorable Supreme Court. We are aware that how the Honorable Supreme Court has given guidelines to ensure that the judgments are delivered within a timeline. Even the Honorable Chief Justices of the High Court has been asked to take care of this. The judge can be given note that the time is going to expire. Actually, what happens is that the litigants or the advocates, they do not point it out to the concerned judge. They are very reluctant to do so. But it is extremely important to give judgments on time, and unnecessary delays actually takes to lot of speculation and anxiety amongst the litigants. And by the time the judgments are delivered, it happens that we forget what was argued in the court. So that is also a very important thing. I just want to share one practice which I have adopted in my court. Whenever I have to reserve a judgment, I hear the parties, then I dictate the short synopsis of arguments, and that argument is also uploaded. And this helps in one way. The parties have an opportunity to point out any error. In 1 or 2 cases, this has happened and I've rectified it accordingly. This helps me in remembering that whatever was actually argued in the court, and further, it stops the party from raising a point which he has not argued in the court. So this is one method which I have adopted, and I want to know your reaction to this. Let us see how you come up with that. Now, conducting court proceedings and judgment writing. These are the various points. I will just quickly, I know that it's almost late afternoon. So I was just indicating that the knowledge of procedural law as well as substantive law are extremely important for judgment writing. Let us see the importance of the procedural law. In order to ensure procedural safeguard in the matter of delivering judgment, the judges are required to commence their journey of writing judgments and scrutinizing the records right from the stage of filing of the case. Before writing a judgment, it has to be verified as to whether the notices have been issued or whether there is a dead person on record. So these are the things. Suppose we write a very good judgment. If there is a dead person on the record, then the judgment is bound to vitiate, howsoever good our judgment may be. So this basic scrutiny is required to be done, although it is the duty of the advocates, but we can't shirk our responsibility so far as this is concerned. Let us take another example. Suppose under the previous law of section 299 of CRPC, the evidence is to be recorded in absence of the accused. If there is any procedural flaw in taking that step, the judgment will vitiate and our judicial hours will be wasted. Another example is that of trial of juveniles. In the cases of heinous offenses by children court, there are 3 checkpoints we all know: the age, whether the offense is heinous or not. If the age is found to be between 16 and 18, required assessment in terms of section 15 and procedural safeguard by the children's court has to be taken into consideration as to whether he has to be tried as an adult or not. The psychological assessment cannot take place at a later point of time when the child has grown up. On account of failure at any stage, the trial vitiates. We have come across numerous judgments of the Honorable Supreme Court where the child is taking a plea of juvenile for the first time before the Honorable Supreme Court, and there is no other option. He's producing such a clinching document like class 10 certificate. There is no other option but to declare that the trial stands vitiated. So our judicial hours are wasted. If we are slightly cautious at the stage of beginning with the point, then these can be taken care of. There are numerous procedural law whose non-compliance is fatal, and the appellate court have no option but to set aside the judgment. What a waste of valuable time. If we see, as I think so, that the appellate courts are occupied with around 20% of the litigation is violation of procedural laws. So if we are able to take care of this, then I think that we will be able to focus more on hardcore litigation. Another example, which is very, very common in Jharkhand, that we are seeing that after the judgment passed in the case of Raziz versus Neha regarding filing of affidavit of assets and liabilities, the judges have not taken care of getting that affidavit filed. And ultimately, after the adjudication, they are fighting on the quantum, and both of them are working. The High Court has no option but to set it aside and remand it back to the concerned court. So these procedural aspects are required to be taken into consideration. It is time to highlight the importance of knowledge of substantive law as an effective tool of quality disposal of cases by way of example from day-to-day basis. The first example which I would like to say is the adjudication under Section 34 of the Arbitration and Conciliation Act. As per substantive law governing the field, the scope of interference is limited and confined to the grounds prescribed in the Act itself. The moment the judge is aware about the scope of scrutiny, his task becomes very easy. The adjudication is precise, brief, and clear, though complete in all respect. However, while adjudicating, the applicable laws as amended from time to time and the judicial pronouncements on the subject are to be kept in mind. In any adjudication, the length of judgment is not relevant. What is important is the substance. We are finding judgments under Section 34 primarily of 2 kinds of errors that we are finding. The judges at times, they deal with Section 34 application as if they are dealing a first appeal. And then we also have judgments wherein one after another of the Supreme Court judgments are quoted, but the grounds which are there in the arbitration 34 application are not dealt with. So these are ex officio procedural error, which is burdening our system to a great extent. In a recent judgment delivered on 26th of July 24, the Honorable Supreme Court has reiterated that the judge has to apply mind to the merits of challenge and also observe that the interference with an arbitral award under Section 34 must be carefully calibrated on the ground which are admissible under the statute and remanded the matter for fresh consideration. Even after issuance of notice in any matter, we need to be careful. At the stage of issuance of notice, we are finding so many cases where they have an alternative remedy, where they have an arbitration clause. So at that stage, a preliminary issue is required to be taken care of. We were just discussing with amongst the judges right now. We are getting cases of compassionate appointment filed after 10 years of date of death. So in such circumstances, at the threshold, instead of asking the authorities to pass a reasoned order and giving them a fresh cause of action to claim compassionate appointment at a later stage, at the threshold, the scrutiny can be done and the case can be given a quietus. Now let us take the remedies under CPC, which are first appeals, second appeals, and revision applications. We know that how the first appeals are to be decided. First appeals are to be decided on all points of fact and law. Nothing is to be left. Rather, I think at the first appellate stage, the High Court, the court should apply an independent mind, go through the entire records, give a point of determination, and then also deal with the reasons which has been given by the learned trial judge. And then only the first appeal becomes complete in all respect. The guidelines have been given in the CPC itself. But so far as second appeals are concerned, they are to be decided on substantial question of law, not question of law, but substantial question of law. What would be the substantial question of law? There are numerous guidelines of the Honorable Supreme Court, although there is no straitjacket formula. Some of the common guidelines, some of the common errors while deciding second appeal, which has been decided by the Honorable Supreme Court, is in the case of State Bank of India versus S.N. Goel. Admitting a second appeal when it does not give rise to a substantial question of law. Admitting second appeal without formulating a substantial question of law. There are other points also. What is important is that first appeal cannot be decided like a second appeal, and second appeal cannot be decided like a first appeal. It is very important that we should know our contours of jurisdiction while adjudication so that our time is also saved. When it comes to divisional jurisdiction under criminal or civil law, we know that it is a very restricted jurisdiction. So our contours should be within that parameter. But at the same time, we cannot simply say that there is concurrent finding and hence no interference. It is in order to say that it is a case of concurrent finding and there is no perversity. It is equally important to go through the records at least once. And at least one or two arguments which are being raised by the parties is required to be dealt with. So it is extremely important for the judge to know his contours of jurisdiction, irrespective of parties raising such an issue. An error of jurisdiction in most of the time makes a judgment a nullity in the eyes of law and is bound to be set aside by appellate court. Such errors increase the burden on the appellate court and are disservice to the litigation and the nation at large. I must say that energy saved is energy produced and time saved is time gained. Application of judicial mind to judgment writing starts from the reading of files, and what this has to be followed by a very patient hearing to the case of the respective parties. And the best hearing can be given only when you have once gone through the case records. It is always necessary to give a patient hearing. That does not mean indefinite hearing. During the court proceedings, it is very important that we should put pertinent questions and the hearing of the party and lead the parties to enter into the core issue of the dispute. In case any core issue is not raised, we also come across situation where the parties are not raising the core issue, but still they are just moving from one point to another. So if it comes to the mind of the judge, then certainly the judge should indicate the core issue to the parties and then ask them to address accordingly. A judge cannot decide on core issue without giving an opportunity of hearing to the concerned parties. The points argued, judgments cited are required to be taken care of at the time of mentioning the argument of the parties, and the judgments are required to be considered. It is also very, very important as to how do we read the judgment. Sometimes the directions passed by the Honorable Supreme Court under Article 142 is taken as a judicial precedent for the courts, and orders are passed on that basis. So this has to be taken care of, that what is the issue involved, what is the ratio, what is the binding precedent or special powers has been exercised by the Honorable Supreme Court. Reading a judgment by itself is an art. So this has to be really taken care of while giving judgments. There is a need to maintain impartiality, neutrality, gender sensitivity, sensitivity towards victims of crime, sensitivity towards children in conflict with law, sensitivity towards members of scheduled castes and scheduled tribes in our judgment, sensitivity towards the dignity of the judicial officers. What is Impartiality requires thinking without being influenced by personal commitments, bias, and preconceptions. For this, a judge is required to rise above all values and perception and proceed strictly in accordance with law. For example, a judge, while deciding a case for an offense under Section 498A, is not to have a preconceived idea that there is a lot of misuse of this section. What is required to be done is find out the basic ingredients of the offense as prescribed based on evidence. Similar is the situation with Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act. A judge cannot assume that the case has been lost to extract money or to settle a score, or it is vindictive in nature. The neutrality means that the judge is non-aligned. A judge may begin neutral and continue to be so in the process of the trial, but at the end he has to decide the case in favor of either parties without any partiality. There is a need to not to disclose the name of the juvenile in the judgments, and there is also a need to not to disclose the name of victim. So these things are required to be taken care of. At the end, I would like to say that we are being judged every day, rather in every adjudication. However, the only person who can judge a judge is the judge himself. I'm extremely thankful to you for this patient hearing. Thank you so much.
Thank you, Your Ladyship, for your extremely invaluable guidance, your enriching insights, and for highlighting the significance of lucid judgments in the public sphere and its impact on public lives. Now, with the permission of the honorable resource persons, I would like to humbly invite the honored dignitaries and esteemed participants to kindly present their views or queries, if any.
This is regarding the view of the sister that arguments should be uploaded. Better,
Yes, sorry.
Yes. I'm responding to that. My way is that it is better to dictate the judgment in the court itself.
So that's right, Lordship. That's absolutely correct. If we are able to dictate it, it's okay. But there are something which happens that you need to deliberate more on that.
So it is better to have it in the court itself.
Certainly, there is no doubt on that.
This is a arrangement which is not sanctioned by law.
That's right.
And then one more thing is that it is said that the plight of a decree holder starts after he gets the decree.
That's right.
Execution is the most difficult task in a civil litigation.
Certainly.
And one of the reasons is that we found several judgments in civil cases where the trial court, even the appellate court at district judge level, will say that decree has been, suit has been decreed. What is the decree? It has not been spelled out. So that relief must be clearly spelled out.
That's right.
Suit is decreed for specific purpose of contracts dated so and so, so and so, so and so. If he deposits so and so, then this will be happen. So that is one aspect which should be taken care of. Thank you.
Another aspect is when a judgment, say a trial court, the judgment, normally what happens, judgment is reserved, and then a particular date a judgment is to be pronounced. It comes in the cause list of the diary date to be dictated or to be listed on so and so date. It is for the trial court, sir, I'm saying. On that particular date, the trial court should seal and make it sure that the judgment is written and it signed it on that and it is uploaded. They don't only pronounce the judgment, it is allowed or dismissed and keep it pending for 10 days to write the judgment. This should not be.
Certainly, this should not happen.
May I ask my Lord Justice Misra? I reminded of a saying of Lord Dennings. Lord Dennings said that I had no time to write a short judgment. Therefore, I had to write a lengthier one. in the today's context, the lot of technology has developed, lot of judgment in every topics. How do you respond to the statement of Lord Dennis?
You are right, and we have no quarrel, and we can't quarrel with what Lord Justice Denning said. But he is right. Why I would elaborate it that I have no time to write a short judgment, therefore I write a long judgment. That means when you don't properly understand the issue, the matter, you don't write the judgment immediately. And the tendency to delay the judgment after reserving it happens more with a matter which you have not properly understood, or you have no interest in writing that judgment. If you understand the issue involved and you have properly phrased it, concised it in your mind, you have the tendency to finish it quickly. Otherwise, you take it, oh, it is a difficult one. This is a difficult one, either bulky or there is some, again, I will use that word confusion. If there is some confusion, you don't have the courage and the competence to write it immediately. And you search for some judgments, you tell your law clerk or your juniors, stenos to search for some judgment. There, you are correct that the judgment which you have understood must be written as early as possible. Otherwise, the judgment which you have, the appeal or the proceedings which you have understood properly, that also you will tend to forget if you delay the judgment. And it is also right that when you don't understand the whole thing properly, you write a lengthy judgment because you cannot pinpoint what is that in the matter. So you write first the plaintiff's case, then the defendant's case, then PW1 to PW3, DW1 to DW3, and the judgment. And in the process, his Lordship Chief Justice is right. And in the process of doing that, you refresh yourself. What was that point in the matter? And then you reach to the conclusion. That is, thank you.
Sir, I'm just asking, sir, let us say an advocate, while arguing a case, raised 8 points, challenged judgment, and he cited decisions on all the 8 grounds taken. And as a judge, I think that these are the 4 grounds which are very relevant. So I deal with all those 4 grounds and the judgment cited on that. And ultimately, I dismiss the matter. He challenged in the higher court forum that I have also raised 4 other grounds, cited the judgments, but the Lennon judge has not dealt with it. So whether all the grounds taken are to be dealt with and all the judgments cited are to be dealt with, or the judge is at a liberty, because on that ground there is every chance of remand of the case to the court that you have not dealt with. So I just want to.
You see, when you are dealing with a civil case, the grounds raised by the party in appellate court, they would be connected with one or the other issue tried by the trial court. The grounds raised in the appellate court, whether it is second appeal or first appeal, they have to be connected with the issues involved in the suit. There is no ground independent of the issues involved in the suit. So the grounds raised, you connect it to the issue which is involved, which is framed by the trial court, and then deal with it. But it is always safer to refer to the grounds and reject it by saying that these grounds are not involved, or rather they are not so material which would affect the eventual decision in the appeal. Likewise, in writ petitions, they slight different. In writ petition, if he argues different grounds, then you are required to deal with it. You may say that the ground raised is referred to be rejected. They are frivolous, but it should find mention in the order. Otherwise, you will find some judge in the superior court who will say that no, this ground is not considered. So it is better to deal with.
Thank you.
Mic दे दीजिए, please hand over mic.
Your Lordship and Ladyship both have given a very useful deliberation for us. Still, I have one query. Lordship, as a court of appeal, when we write a judgment in appeal, in first appeal, then we start, we have a practice to start the rewriting the case of the party as has written in the trial court record. First, we start case of plaintiff, defendants, issues, and thereafter the evidences. Lordship, if we adopt a practice to write the judgment of appeal in continuation of the judgment of the trial court, by taking out the original judgment from the trial court record in appellate court record, by replacing it in photocopy for all purposes, and start writing the judgment in continuation of trial court judgment, then we can save a lot of time in writing the case of the parties, and save of reputation of the things, and judgment should not be bulky, may not be bulky. So why we not adopt such practice? There will be another benefit, that whole judgment, entire from trial court to High Court and Honorable Supreme Court, one may be available in one seats of the judgments. Then why we not adopt such types of practice? And my another query is, your Lordship and Ladyship has highlighted and elaborated that judgment is for the litigant, and it should be perceived by a common person. Then why we are not adopting a methodology to write a judgment for the civil judges and judicial magistrates in the language of the local persons, by appointing Hindi stenographers, just like Jharkhand and Orissa, both are the tribal states, and litigants are depends on the information given by the advocates. They don't know what judgment has been passed. They can't read and they can't understand.
First,
So
I'll take up your second question first. Right? In Jharkhand, at least, we see that the judgments are written in vernacular languages. Judges are writing judgments in vernacular language. And I think in Odisha also, it must be open to them to write judgments in vernacular languages. Open, right? Now there is a trend that the judgments are to be translated also. So if any judicial officer wants to write a judgment in vernacular language, there is no bar about it. Rather, if it is if the litigant is better understanding that, there is no problem. At the High Court level, those who do not know the language, suppose a judge from South India comes, then we have an official translator over here. So there should not be any problem about it. So far, your adjudication of your first appeals are concerned, at the stage of first appeal, a second look at the entire records is to be given. We are also facing situation wherein the first appellate judgment is copy-paste of the original trial court judgment. Absolutely word by word, comma, full stop, copy-paste. At least that should not happen. So therefore, the judge at the first appellate stage has to give an independent mind to the records then see the trial court judgment, see the reasoning of the judgment, and the question of differing with the findings comes only when you differ with the reasoning. So it is something like, going to a second opinion to a doctor. So therefore, this has to be taken care of. It cannot be just copy paste. In fact, one or two judgments I have set aside by saying that it is absolutely copy paste. So this should not happen. Point of determination has to be there before the first appellate court. We have the procedure under the CPC as to how the Order 41, Rule 31, that those, 33, the entire, it is there in the CPC, how the first appellate court has to take up the matter. And it also assumes importance because of the reason that the first appellate court is a final court, not only on fact, but also on law. Second appeal is dealt with only on substantial question of law, not on all questions of law. So being very sensitive to the litigants, we have to take care of this aspect of the matter. Did I answer your question? Could you get that?
Youngest judicial officer.
Could you get?
हम कहना चाह रहे हैं कि जब हम लोग अपीलेट कोर्ट के जजमेंट के आगे ट्रायल कोर्ट के जजमेंट के उसी सीट पे अगर अपीलेट कोर्ट का जजमेंट लिखना शुरू कर दें, जो फैक्ट को बिना लिखे हुए, पार्टी क्या क्या एविडेंस दिया है उसको बिना लिखे हुए, जो अपीलेट कोर्ट का आगे जो रीजनिंग हम डिफर करें, जो पॉइंट ऑफ डिटर्मिनेशंस बनाए,
कोई भी चीज, कोई भी लॉ बिना फैक्ट के डिसाइड नहीं होता है. अगर जरा भी फैक्ट में, मटेरियल फैक्ट में फर्क होता है तो जजमेंट फर्क हो जाता है. इसीलिए बहुत जरूरी है कि आप एक बार पूरा रिकॉर्ड को फिर से देखें. इट इज एब्सोल्युटली नेसेसरी. देयर कुड बी, अगर मान लीजिए कोई भी मटेरियल फैक्ट अगर ट्रायल कोर्ट, अपीलेट कोर्ट, सेकेंड अपीलेट कोर्ट भी अगर छोड़ देता है लिखने से, एंड इफ इट इज सो मटेरियल, then even the Honorable Supreme Court will set it aside as perverse.
Let me. What I have understood, जैसा हमने समझा है आपके प्रश्न को,
जी,
आपका ये सोचना है कि ट्रायल कोर्ट का जजमेंट जहां खत्म होता है
वहीं से लिखना शुरू करें,
वहीं से अपीलेट कोर्ट अपना जजमेंट शुरू कर
अपनी फाइंडिंग देते हुए,
ताकि वो फैक्ट वगैरह जो है फिर से रिपीट
नहीं करना पड़े, और सारा चीज जो अपीलेट कोर्ट का ऑर्डर 41,
दिस वुड बी wholly impermissible in law.
Yes.
You see, each court has its own record. The case is numbered in that court, and the appeal in the appellate court starts from the memo of appeal, the grounds urged therein. It's a different record. You cannot continue with the record of the trial court by using the same sheet of paper and start writing the judgment from where the judge of the trial court has ended.
Yes, Lord.
This concept is inconceivable in law. You better don't think in those terms.
The grounds are to be taken care of. There could be amendment, there could be additional evidence, there could be change of nature of parties also. Order 41, Rule 31. Yes. That's right.
Not necessarily even the facts has been correctly mentioned by the trial.
Certainly.
The other aspect is that the first appellate court has to give his finding on the facts. So he cannot continue what was left. So as his lordship said, it's unthinkable.
Any other query?
Junior officer.
If you do not put questions, we will take that you have not heard us. Yes, please. सो गए क्या लंच के बाद?
चाय पिलाया अभी क्वेश्चन करेंगे.
ऐसा ना करें प्लीज, जो मन में आए क्वेश्चन करिए.
I thank all the honored dignitaries and esteemed participants for their kind participation in this interactive session. Before we wind up this session, we would like to take the opportunity to felicitate the esteemed and honored speakers of this session as a mark of our immense veneration and appreciation. For this, I humbly request Honorable Shri Justice Chakradhari Sharan Singh, Chief Justice, High Court of Orissa, and Patron-in-Chief, Odisha Judicial Academy, to kindly adorn the Uttariya and present the memento to Honorable Shri Justice Prashant Kumar Mishra, Judge, Supreme Court of India.
Thank you.
Thank you, Your Lordships. I now humbly request Honorable Dr. Justice Sanjeev Kumar Panigrahi, Judge, High Court of Orissa, and Member, Judicial Academy and Training Committee, High Court of Orissa, to kindly adorn the Uttariya and present the memento to Honorable Madam Justice Anubha Rawat Chaudhary, Judge, High Court of Jharkhand. Thank you, Your Lordship and Your Ladyship. With the end of this session, we have now come to the end of the sessions that were scheduled for today. We shall resume with the East Zone 1 Regional Conference with the commencement of the 4th session tomorrow at 9:30 a.m. Till then, thank you and have a nice day. We would also like to invite all the honored dignitaries and the esteemed participants for a state dinner at Mayfair Convention Center from 7 p.m. onwards today. Cultural program and state dinner. Okay. We also have a cultural program scheduled at 7 p.m. at Mayfair Convention Center. We hope to see you there. Followed by state dinner.